State Department of Investment Promotion, Abubakar Hassan Abubakar, the representative from the AG's office, Honorable Chiboy, the Board of Directors of the NCIA, ladies and gentlemen, all protocols observed. Good morning again.
Good morning.
I stand before you representing Safaricom, and in particular our Chief of Corporate Affairs, Stephen Kiptines, who could not be with us this morning, but sends his greetings. Mine is a very easy task. It's to give a talk on the perspective of a user of arbitration services, and in particular, gearing for the changing times and exploring the perspectives for arbitration. So thank you once again for the invitation to Safaricom to both participate in as a sponsor in this arbitration week. There is a Kiswahili saying that goes, siku njema huonekana asubuhi. And loosely translated in English is that a good day is seen in the morning. And it has not only been a good day today, but a good day the entire week in this particular Nairobi Arbitration Week. Congratulations to the Center for arranging this very, very good symposium and conference for each one of us. Now, it has been a wonderful week of exchanging ideas, learning from our collective experiences as practitioners and users of alternative methods of dispute resolution. I particularly wish to recognize the critical and invaluable contributions of the NCIA to the development of rich jurisprudence and policy direction in the local, regional, global, commercial arbitration space. We have had during the week from many practitioners who have come from far and wide, each one of us converging with our different experiences in order to make alternative dispute resolution a more enriched alternative in our areas of expertise. The focus of this arbitration week has been on multiple topics of interest, ranging from technical and practical issues facing ADR practitioners in the construction, arbitration, regional agreements in place, and the application and relevance to the realities of ADR practice, to the roles played by arbitral institutions across the globe, and the challenges and opportunities that this presents. The discussions have been engaging, and the collective commitment by all stakeholders towards improvement of this space is commendable. In line with this, Safaricom is now well on its way to stamping its identity as a technology company by 2025. The mission enables us to keep our promise to our stakeholders in line with our purpose to transform lives. And one of the things that we would like to ask all the participants today is to engage with us and consider technological solutions in your day-to-day work. We hope to achieve this purpose by embodying and exemplifying collaboration, customer obsession, and innovation as a way of life. Partnership opportunities as the one that is presented today through the active participation in the Nairobi Arbitration Week further speak to these efforts, and it is our sincere hope that they will endure long after its conclusion. We're now firmly in the digital age. I believe each one of us has a digital device, if not two. And we have engaged with it from the moment we have woken up, and probably will be the last thing we use before we go to sleep. So true to the words of the renowned artist Bob Dylan, the times are changing. And there are people from perhaps the West Indies who say times are changing. And to quote a few words from this acclaimed song, it says, "Come and gather round, people, wherever you roam, and admit that the waters around you have grown, and accept that it's soon you'll be drenched to the bone. If your time is worth saving, and you better start soon, or you will sink like a stone, for the times are changing." And indeed, I believe times are changing, and arbitration will be one of the methods that really embrace change and make the issue of dispute resolution different from what we knew. The message is simple. If we are to remain relevant, we must be adaptable as ADR practitioners, just as the environment in which we are changing. A few weeks ago, we had the opportunity again to partner with the Center of International Arbitration And one of the things that happened during that session is one of the practitioners decided to show us what technology can do, ChatGPT. I think we are all conversant with it, not to say that it is the preferred choice of technology that we should adopt or not, but indeed times are changing and we must adapt. Advancements in technology present both opportunities and challenges for arbitration practice. Technology has now changed to how we live, how we work, how we connect, to previously unseen skills. I have noted that while we have been in this session, there's nobody who has been online. Perhaps there are some of the guests who would have wanted to be with us today or this entire week, but would not have made it. It would have been good to have an opportunity for them through technology to still be present. Depending on how we react to it, our experience is either simplified or made more complicated. I know a lot of us as lawyers, perhaps we are stuck in our ways, as practitioners we're stuck in our ways, but technology is here to help us advance. Disruptive technologies continue to emerge in every passing minute, be it artificial intelligence, which we had, I believe there is a session for that, robotics, machine learning, and Internet of Things, to name a few. So what does this herald for the future of arbitration? Number one, the need to have continued collaboration with technology as an enabler of expeditious, effective, and justiciable resolutions of disputes. The tech revolution continues to challenge conventional arbitration procedures, not only across product businesses being conducted on online platforms, but emerging technologies are coming up with new models of payment and business interactions, and arbitrations must similarly align to these emerging models. AI has brought automation and predictive analytics into the arbitration process. It can assist in document review, predict case outcomes, and even in selecting arbitrators based on their expertise. But this is not to say that we are completely doing away with the human intervention and the need for human intelligence. Number two, renewed focus on dispute avoidance and its ties to relationship management. It is acknowledged that arbitration comes in where disputes have already arisen. The clarion call, however, remains to practitioners to engage in the business of client counseling and dispute avoidance, if for no other reason than to maintain the relationship between the parties, to maintain a conducive environment for social and economic development. This will also increase parties' receptivity towards decisions of arbitral bodies and improve the credibility of institutions. I'm sure some of us who are users of the arbitration process have probably a different view from the practitioners depending on what type of award you received. Partnering for success. We must continue to drive awareness of the benefits of adopting technology in dispute resolution and work together in the development of solutions that will enable us to achieve this. Trust in the process. Arbitration offers flexibility, neutrality, confidentiality, all of which are crucial for parties seeking to protect their proprietary information and navigate the intricate web of disputes. With the application of technology to improve efficiencies, these advantages are maintained with faster, more affordable, and user-friendly aspects included, resulting in positive outcomes for all involved. As I conclude, I reiterate Safaricom's commitment to the achievement of the mentioned goals, not only as a technology partner, but also as an ethical and responsible corporate citizen with a firm belief in the development of all facets of our society. A robust legal framework is the bedrock of any thriving business environment, and we are dedicated to upholding the high standards of legal excellence and partnering towards the practical achievement of the objectives of the Ncia and affiliated bodies. We continue to collectively make great strides as practitioners of alternative disputes resolution methods, and can always do more towards ensuring justice for all. We are proud to be part of this vibrant legal community and remain steadfast in our commitment to you as stated today. Thank you once again for having us, and I look forward to future engagements such as this. Again, congratulations to the NCIA for this wonderful, wonderful organized week of arbitration. and dispute resolution. Thank you.
Thank you very much, Ngeshi. We indeed cherish the partnership that we have had with Safaricom since our first conference in the year 2016. We consider you a valued partner. Indeed, arbitration looking to the future, as you say, in times of change, we cannot but embrace technology in the way we do things. It's now my privilege again to welcome the chairperson of the board of directors, Nairobi Center for International Arbitration, to give her remarks and invite the chief guests.
You still remember. All right. Once again, good morning, everybody, and welcome. I will not be making any remarks this morning because I want to ensure that you all attend the gala dinner this evening. So I will reserve my remarks for the evening, and also in the interest of time, having lost some time this morning. So it is my distinct privilege to welcome our keynote speakers this morning. First, I want to recognize the presence has already been recognized of the protocols observed prior, but I do want to distinctly recognize the Ncia board. So I'll request you, wherever you are sitting, please stand. Because some of you may not have had the opportunity to interact. So a very quick round of introduction, starting from my right, Waidi Kamal, representing the Office of the Honorable Attorney General. Thank you. Kanana Mutea, who is a nominee of the Chartered Institute of Arbitrators. Thank you. Sam Biriri, who is a Chair Emeritus of the Chartered Institute of Arbitrators and is also in that capacity a representative of the Chartered Institute of Arbitrators on our board. Thank you. You have already met Lawrence Mwiri, who is our very capable, very erstwhile CEO and registrar. Thank you. And last but not least, Aisha, who represents the Kenya National Chamber of Commerce, is also a partner at Angelana and Kama. We have several of our directors not present. Judy Omange, who represents the Honorable Chief Justice, and of course, we have Laura Lusiji, who is a representative of the Law Society of Kenya. So thank you, directors. I want to invite, because we have agreed, we are dispute resolvers, so we agreed before we came into this room who would speak first. There are normal protocols that are observed, but in the interest of perhaps other exigencies that the two speakers have expressed this morning, we will be hearing first from the Honorable Moses Chiboi in his capacity as representative of the Honorable Attorney General. So karibu sana, Honorable Chiboi.
Thank you very much, Chair. P.S. Trade, Chair here, directors, all distinguished guests, ladies and gentlemen, good morning. I am here for the second time this week. I was here on Monday, and I must confess, Madam Chair, that I was severely intimidated then because the team that was handling Monday, composed of very able, strong ladies, particularly the women in ADR. And as I was seated somewhere, the Deputy Speaker, Kenya National Assembly, my successor, made a comment, which I took very keenly. She said, we shouldn't refer to our lady colleagues as rainbow. And that was fine. I agreed with her. But unfortunately, I am married now for 30 years. And every day I go home, I will refer to my wife as beautiful, and she will respond always, hands up. Even if, of course, I know that doesn't really fit the description. I've been happy with it for 30 years. But that evening, Madam Chair, I must report to you that I didn't do that because I was not so sure whether they had also discussed with the attorney, the Deputy Speaker. So I went silently and, greeted her, and she did what she normally does, and wondered whom I had actually seen that day that I could not refer to her as beautiful. So when I was probed, I did not become a good lawyer then, I said I met Gladys. That became even a worse situation. But I thank you, Madam Chair, and your team, because there are some things which I hear that I took home. And I'm not going to tell everybody else what it was, but I can tell you it severely, it really helped me deal with some of the few things. So I'll be very careful today, but at least I've talked to the Speaker, the Deputy Speaker, and we agreed that she said it is only when it's on official capacities. But at home and elsewhere, feel free to call each other anything. So I'm here to represent the Attorney General. I am going to be, I will read the speech. I will not summarize it because I don't have that instruction today. I have been his deputy for quite some time in other capacities. I've been his deputy when he was the minority whip in Parliament between 2002 and 2007. I ended up becoming his deputy as a speaker in 2017-2022. Currently, I'm not so sure whether I'm deputizing him in anything, but I'm sure I'm his deputy in terms of his speech reading. I do it all the time. And I can tell you, Madam Chair, he really wanted to be in this particular function. And I can tell you, because I have spoken to you elsewhere about it, he was very categorical that he was going to come until something cropped up, which was a follow-up about a meeting which he had in London with some government officials there. So he's dealing with it, and I'm sure if he gets time, he probably will be passing by later in the day, especially that evening gala. I'm trying to convince him. I know he likes galas himself. I hope he will be joining me. So I'll read his speech. I will, as I've said, it's not a very long one, but it's not short either. So it will depend really on how quick I'm able to read it, but I think it should be around 10 to 12 minutes. If it goes to 15, it's because I was a bit slow. So, distinguished guests, ladies and gentlemen, all protocols observed, I take this opportunity on behalf of the government of the people of Kenya to extend a warm welcome to you all to Kenya. As the Attorney General of the Republic of Kenya, I am delighted to be in the midst of such esteemed gathering at this inaugural Nairobi Arbitration Week 2023. Karibuni. It is my hope that you have had a chance to enjoy the hospitality of Nairobi and the Kenyan people. I congratulate the Nairobi Center for International Arbitration for taking bold steps to host the inaugural Nairobi Arbitration Week 2023. This week serves as a testament to the growing significance of dispute settlements through arbitration and other forms of ADR in our ever-changing global landscape. As I commend the Nairobi Center for International Arbitration for this remarkable event, I also acknowledge the rich participation of law firms and other entities in this space who I note have made immense contribution to the Nairobi Arbitration Week 2023. As this week ends, it must be abundantly clear why the theme, gearing up for changing times, exploring perspectives for arbitration, which I believe has permeated the various sessions that were selected. It becomes evident that the need for adaptable, innovative, and forward-looking approaches in the field of arbitration has never been more crucial. This event has provided us with a unique opportunity to collectively engage in knowledge exchange, foster collaboration, and challenge our views of modern dispute resolution. You will no doubt be aware that the public sector or the state is the foremost user of cross-border and investment dispute settlement. Speaking on behalf of my jurisdiction, Kenya, we are committed to resolve disputes through various international instruments to which Kenya is a signatory, even as we actively participate in addressing areas of systematic reform in which the state is a party. Our record as a state party speaks for itself, with an impressive success performance. In addition, the Convention on the Enforcement of Foreign Arbitral Awards, New York Convention, entered into force in February 10, 1989, demonstrating the commitment to honor enforcement of foreign-seated awards. Since 1995, Kenya has enacted the Model Law on Arbitration, the Arbitration Act 1995. The legal landscape has been shaped by a robust jurisprudence, which underscores the judicial affirmation of limited role of court intervention and support for arbitral process. To support the legal infrastructure, the judiciary has facilitated key interventions such as the establishment of the commercial divisions of the High Court, increase in special capacity of judges that have been practitioners of arbitration, mediation and ongoing training of judges and other judicial officers. The Law Society of Kenya, on the other hand, has also played its part in embedding continuous professional development programs in ADR and participating in events on trends on global practices such as the Nairobi Arbitration Week. My office appreciates the pivotal role that dispute settlement through arbitration plays in our globalized and interconnected world. It serves as a powerful tool to resolve disputes efficiently, confidentially, and impartially, while promoting the international trade and investment. As we convene here today, we acknowledge the success of arbitration. The success of arbitration lies in our ability to ensure the independence, integrity, transparency, and the transparency of the process. The world we live in is rapidly evolving, driven by technological advancement, geopolitical shifts, and changing economic dynamics. As arbitration practitioners and enthusiasts, we must acknowledge that status quo is no longer enough. To remain relevant and effective, we must proactively embrace change and explore new perspectives to meet the challenges of the future. The digital era has revolutionized the way we conduct business, communicate, and resolve disputes. Online platforms have disputed traditional business models, creating new challenges and opportunities in arbitration. In response, we must harness technologies at potential to streamline arbitration procedures, increase efficiency, and enhance access to justice. However, with technological advancement comes concern about data privacy, cybersecurity, potential bias on algorithms, and as guardians of justice, we must tread carefully to strike the right balance between efficiency and fairness, and the future of arbitration rests in our ability to master technology while preserving integrity and values of the arbitration system. Moreover, globalization has made the cross-border transactions and disputes a common reality. In the interconnected world, arbitration has emerged as an essential tool to resolve international conflicts. Embracing diversity and recognizing the impact of different legal systems and cultures, it is vital in making arbitration a truly global and inclusive mechanism. Let us acknowledge the role of sustainable development in arbitration sphere. Climate change and environmental challenges are no longer abstract concepts, but tangible realities affecting nations and communities worldwide. Arbitration must adapt to address disputes arising from environmental concerns and corporate social responsibility, paving way for greener and more sustainable future. Another crucial aspect that we must explore is the role of arbitration in promoting gender equality and diversity. By fostering an inclusive environment and encouraging equity and equal representation in arbitration panels and leadership roles, we can ensure fairer and more balanced outcomes. To gear up for the changing times, we must invest in education, professional development of young talent in arbitration. Emphasizing mentorship programs, internship, and workshops will enable the next generation to rise to the occasion and lead the field with fresh perspectives and innovations. I am aware that the Ncia afforded young arbitration practitioners the opportunity to attend this week's event at a concessional rate. I urge the senior tier of the profession to entrench corporate social responsibility to raise young talents in arbitration. As we embrace these changing times, we must also recognize the success of arbitration depends on collective effort of all stakeholders, governments, institutions, practitioners, and parties involved must collaborate to foster a conducive environment for arbitration to thrive. In Kenya, we have made significant strides in strengthening our legal framework to create an arbitration-friendly environment. Our Arbitration Act reflects the international best practices and principles, providing a robust foundation for arbitration proceedings. The recently approved Alternative Dispute Resolutions Policy is further progress to modernize the practice as we continue to develop our arbitration and ADR infrastructure. We remain committed to upholding the rule of law and ensuring access to justice for all. On the same breath, I appreciate the remarkable effort by the Nairobi Center for Arbitration, NCIA, in spearheading the formulation of the Alternative Dispute Resolution Policy in Kenya. The journey towards establishing comprehensive ADR policy in Kenya has been nothing short of inspiring. It is a testament of unwavering commitment, dedication, and vision of NCIA team. Today, we gather not only to acknowledge their exceptional contribution, but to also enhance a significant milestone in the evolution of our country's arbitration landscape. The Nairobi Center for International Arbitration has tirelessly worked to champion the cause of ADR in Kenya. Its expertise, relentless advocacy, and invaluable partnership it has forged has led to the realization of this groundbreaking policy. This achievement is not just a policy, it is a catalyst for change, and it empowers businesses, individuals, and communities alike to resolve disputes swiftly, fairly, and amicably. It positions also Kenya as a regional and global leader in promoting peaceful conflicts resolution and fostering an enabling environment for commerce and investment. The Center initiated the arbitration rules in 2015. It recorded the first dispute the following year, that is 2016, and I note the trajectory of growth in caseload, value from 25 billion Kenya shillings, which is approximately 250 million US dollars, as from June 2022, to 147 billion Kenya shillings, equivalent to US dollars 1 billion by June 2023, an increase of 125 billion Kenya shillings. It is instructive that this same period, the Center has registered international arbitration filings and the nature of disputes cuts across sectors that are key drivers of our economy and the region, that is finance, construction, technology, supply, and delivery. On capacity enhancements for local practitioners, I note that this is the fourth international event following the 2 international arbitration conferences and 1 China-Africa arbitration conference organized by the Center. The young practitioners have also benefited from the Center's national and regional arbitration moot competitions involving 25 universities across East Africa. Within 1 year and a half of the launch of the Center training curriculum, more than 457 practitioners have received various training courses under the auspices of the Center, including my own state council, the AD State Council, who this year received intensive investment arbitration training. I have observed from the program that the last 3 days of the Nairobi Arbitration Week had also a training for council in arbitration collaboration with SOAS University of London. The strides made by the Center have received accolades from the international community. The collaboration with global arbitration institutions, users, and practitioners worldwide has placed Nairobi on the map as a prominent arbitration seat, attracting cases and establishing Kenya's credibility as a reliable arbitration destination. Last year, 2022, I acknowledge the recognition accorded to the Center in winning the Arbitral Institution of the Year 2022 award at the African Arbitration Association Conference in Accra, Ghana. I again have the pleasure to laud the team for the recent award as the leading provider of the year 2023 during the recently concluded East Africa International Arbitration Conference in Zanzibar, Tanzania. Ladies and gentlemen, this week's long series of events has undoubtedly sparked the insightful discussion and illuminated the cutting-edge development in arbitration. I am encouraged to note that the participants were actively engaged in the sessions, shared their experiences, and challenged the conventions and wisdom. The exchange of diverse perspectives is what fosters the growth and innovation in the legal profession. I wish to express my deep sense of appreciation for the remarkable support and collaboration we have witnessed during the Nairobi Arbitration Week. This week has been a testament of the power of partnership and collective commitment to advancing the field of arbitration. All organizations that generously sponsored and hosted the side events throughout the week have also added significant value that enriched discussions in diverse ways. I'm sure the AD is referring to the very serious sponsors like the gold sponsor here and the silver sponsor there and the rest of the sponsorship. These are the very serious organizations and users of arbitration in Kenya. Your belief in the importance of promoting dialogue and acknowledging and knowledge sharing is deeply appreciated, and you have not only made this event a reality, but also facilitated the exchange of ideas and experience that will shape future of arbitration. In conclusion, as you wrap up the Nairobi Arbitration Week, I urge you to carry forward the knowledge, insights, advance the cause of arbitration, both in Kenya and on the international stage. Together, we can foster a stronger, more vibrant arbitration community that delivers economic advancement by facilitating disputes settlement. Once again, I thank you, the host, for making this event a reality. I want to extend my heartfelt gratitude to each and every one of you who actively participated and engaged during this year's Nairobi Arbitration Week. Your presence has been instrumental in making the event a resounding success. Please take some time over the weekend to savor the sights and sounds of the Kenya before returning to your respective destination. And for the visitors who come from far and wide, this is the season where there is the annual wildebeest migration in the Mara. Please take advantage of it if you have time. And we look forward to future collaborations and continued growth of arbitration in Kenya, the region, and globally. I hope the NCIA will make this biennial, if not an annual, calendar event. I do not have instruction on that, but I could change this biennial to annual. And I will talk to him immediately after this to tell him that I think there was a typo. I have known him for some time, and I know when he has made some small typo. Thank you very much, honorable guests, distinguished ladies and gentlemen. After this, I will be seeking leave. I know the chair made a mention. My wife is graduating with a postgraduate degree, and I have to join her, especially after I made some small mistakes, courtesy of you this Monday. Thank you very much, and God bless you.
Thank you very much, Honorable Chaboy. And as we previously agreed, we will not hold you beyond the necessary time that is required. I then want to invite a professional colleague who previously served with the Capital Markets Authority, for some of you who may be familiar with him, but is now serving our central government as Principal Secretary in the State Department for Investment Promotion in the Ministry of Investment, Trade and Industry, Abubakar Hassan Abubakar Karibu.
Welcome to Kenya, the land of endless opportunity. Kenya, it's the door that opens up to Africa. Extending into the world, where great ventures lead to new frontiers, beating new paths off the beaten trails, where industry meets opportunity. This is the cradle of human enterprise. Opening a world of growing possibilities. The place where preparation is the path to potential. And magic is just footsteps away. This is the meeting point of ingenuity and enterprise, where your dreams and hard work are secured and your boldness is rewarded. This is the land where the future lives and your tomorrow begins. Make it.
And when we do a micro checkup, we just say 1 billion, 2 billion, instead of saying 1, 2. Honorable Moses Cheboy, Chair of Advocate Complaints Commission, representing Honorable J.B. Muturi, the Attorney General of the Republic of Kenya. Mheshimiwa, you forgot to say beautiful wife, not wife, because you are used to Mrembo. Jacqueline Oyoyo Gedinji, Chairperson, Nairobi Center for International Arbitration. Board members of the Nairobi Center for International Arbitration. Lawrence Ngugi, the CEO, Nairobi Center for International Arbitration. Ladies, distinguished ladies and gentlemen, all protocol observed, good morning. And for the visitors and non-Kenyans, welcome to Kenya, a home of the human origin. It has now been scientifically proved that Kenya is where humanity began. So by coming to Kenya, you've just come home. And two, welcome to Nairobi, the only city with a national park in it and covered by the forest canopy. Ladies and gentlemen, I'm deeply honored for this invitation and delighted to be here before you today. I commend the Nairobi Center for International Arbitration for putting together this event, which I'm confident will address pertinent issues relating to how we can attract and facilitate global investment and trade through impartial, effective, and efficient settlement of disputes. You know, our country is a net importer of goods. But now there is a strategic shift of the strategic intent of this administration, which informs our strategic direction to be more of importation of capital, hence our foreign direct investment target. This government has made a decision that it will be led by private sector investment-led economic growth. And that is why this State Department of Investment Promotion was created. It is a private sector State Department to provide a nexus between the private sector and government. And the mandate of this State Department is to coordinate the promotion of private investment into the Kenyan economy, continuously engaging the private sector to identify impediments to be removed and incentives to be created, and oversighting incentivized economic zone. The aim of this State Department is to position Kenya as a preferred and investment destination in Africa. And we've been given a target, and the target is the FDI target of $10 billion US. Our strategies to achieve these targets is threefold: investment attraction, investment facilitation, and investment enablement. Under each target, we have three sub-strategies. Under investment attraction, we are enhancing our investment climate and business environment, building investment-grade opportunity, and aggressively marketing the investment climate plus the investment-grade opportunity. And our investment facilitation strategy, we also have a three-tier model. We have a one-stop center at Kenya Investment Authority, and if you feel frustrated, there's an appeal mechanism to the State Department of Investment Promotion and the Minister of Investment, and if you still feel frustrated, the President has operationalized National Investment Council, chaired by themselves, to sort out the investment facilitation issues. The third strategy is investment enablement. In Kenya, we have a robust banking system and a deep capital markets. But in addition to that, we have simplified our public-private partnership and have a program for de-risking private investment through co-investment and granting private investors incentivized special economic zones and export processing zones. However, these investors, before they put their money, there are three things they usually consider. And I will say these three things 4 times, in fours. In Kenya nowadays, everything is in threes, but I will say threes 4 times. One, foreign investors, that's our target, is about where is the location, the strategic location of this country, the energy and the infrastructure of that country. The second batch of 3 is the political environment, economic environment, and the security environment. The third batch of 3 is what are the resources in that country, the efficiency about the business environment, and the market access. We are proud that one of our biggest resources, which is according to the World Investment Report, is that we pride ourselves with our robustness of our human capital. However, the last batch of 3, the investors look for, how am I being treated in that country? 2, how is my investment protected? Or will my investment be protected? And 3, dispute mechanism should there be a dispute. And that is why that's our connection between this State Department and the Nairobi Center for International Arbitration. Our Constitution, Article 159, mandates the judiciary to promote ADR in the administration of justice. Our country is a party to the International Dispute of Resolution Forum, including the International Center for Settlement of Investment Disputes. And the Nairobi Center for International Arbitration Act also provides for a regional center for international commercial arbitration. With a focus on FDI, we are seeing more of bilateral investment treaties to be signed and potential foreign disputes to be arbitrated. So we need to actually position ourselves to make sure that there are no exportation of disputes abroad, but they remain here and there's value addition to those disputes here at the Nairobi Center for International Arbitration. Ladies and gentlemen, the Cabinet has approved the ADR policy with the objective of enhancing the effectiveness of the arbitration ecosystem and the infrastructure, and the State Department of Investment Promotion is working closely with the Nairobi Center for International Arbitration on how to make this center investor-centric. To prevent disputes, because dispute resolution is costly, the investment policy, the National Investment Policy 2019, provides for establishment of a business ombudsman at the National Investment Council, which is chaired by the President. I'm reliably informed that since the Nairobi Center for International Arbitration was operationalized, it has sorted or resolved or in the process of resolving dispute worth over $1 billion. It is indeed a center where disputes meet resolutions. Arbitration, as we all know, is a cornerstone of international investment and trade. It offers an efficient, transparent, and impartial means of resolving dispute, fostering trust, and promoting economic growth. As the PS for State Department of Investment, I want to emphasize the importance of a robust and effective arbitration framework for our nation. Kenya has made significant strides in establishing itself as an investment hub in the region and the continent of Africa. And we want also for the Nairobi Center for International Arbitration to be the dispute resolution hub for Africa. I wish to challenge the Attorney General's office, and I think they are being represented here. As we negotiate this bilateral investment treaty, there have been concerns of the government that there have been, when they were negotiated, the format was an old model format, and it doesn't take into consideration the new emerging issues of this country, of many countries in Africa, and the development priorities of African countries. So I want to challenge the AG to see how, if they can audit all the bilateral investment treaties which have been signed so far, to see if there's a need for revision in line with the new model and in line with the Africa FSCTA investment protocol. And I also urge the Nairobi Center for International Arbitration to strengthen their capacity so that we can enhance the confidence of the foreign investors. In conclusion, the Nairobi Arbitration Week serves as a testament to our collective commitment to the principles of arbitration and the rule of law in the international investment and trade. As we face the challenges of a rapidly changing world, we must remember that a strong and a reliable arbitration system is the linchpin that keeps global commerce moving forward. I encourage all of you to engage actively in the discussion and events of this week. I'm told there is already been done. Share your insights and explore new avenues for collaboration. Together, we can continue to improve the practice of arbitration and ensure that it remains a vital tool for promoting investment and upholding justice. May this gathering continue to advance the cause of dispute settlement and strengthen the bonds of international investment and trade. With those many few remarks, thank you very much and God bless you.
Yes, before we leave the stage, we have a gift for you. And I will be requesting on behalf of the center that you share this video with us so that we can also open our various meetings with that video. Ladies and gentlemen, we thank both the PS, Ministry, and of course the representative of the Honorable Attorney General for their comments. I think you will take back with you the message of collaboration, the message of continued conversations around the enabling environment that Nairobi and indeed Kenya continues to encourage. I know that the PS has an engagement, a forward engagement that he needs to attend to, so allow us then to give him the grace to leave, even as we continue with the rest of the program for today, and invite perhaps the next session chair then to take forward, even as we escort the PS out. So the next session chair, please take the podium.
morning once again. Before the next chair of the panel comes forward, let me invite Director Aisha. And Ms. Wangeshi Ishuki come forward to receive a gift from the center. And now we'll transit to the next session, which is a panel that will be directed by Director Kanano. So please take the floor.
Great. Good morning, everybody. Good morning. I know it's been a long morning, and we seem to have overrun a little bit on time. So this is going to be my suggestion to you, with the hope that I'll have your cooperation. I know the team outside, the catering team, indicated that they were serving tea for 10. My ask would be, it's now 10:55. Can we grab our snacks, come back in, proceed with the debate as we take some of the snacks? Is that acceptable, so that then we use our time and then also hopefully get some cerebral conversation happening? Is that okay? So people are smiling, they want this to happen. So I promise you a very good session with a very good panel discussing crippling awards, and I do hope that we have good engagement from you because our panel is ready and raring to go. So kindly, please, in about 5 minutes, because the stations are different, please just grab your tea, coffees, whatever lovely snacks they have, and then kindly come back in. Thank you.
The Nairobi Center for International Arbitration is located at the heart of Nairobi, one of the most international and vibrant cities in East and Central Africa. The NCIA is easily accessible with its convenient locale in the vicinity of international airports. The center was established in 2013 via an Act of Parliament to facilitate and promote the conduct of international commercial arbitration, as well as alternative dispute resolution mechanisms. The available dispute resolution mechanisms adopted by the NCIA are convenient, quick, independent, and up to international standards. Since the inception of the NCIA arbitration and mediation rules in 2015 to the present, we have provided alternative dispute resolution services. Since its inception in 2016, the Center has seen a steady increase in the referral of disputes under the NCIA arbitration and mediation rules. Currently, the Center has reached a significant milestone of cases referred, marking a notable upward trend over the past 7 years. The case value by the end of December 2022 had risen to 25.25 billion Kenya shillings, equivalent to $210 million. The largest single claim recorded is equivalent to $50 million. NCIA rules provide a state-of-the-art procedural framework for dispute resolution through arbitration and mediation. Over the years, the cases typically anticipated at the NCIA emanate from the construction, supply and delivery, technology, finance and employment sector. In promoting diversity and neutrality, the NCIA has impaneled arbitrators and mediators drawn from different nationalities. The vision of the NCIA is to keep up with technology and modern innovation and to facilitate alternative dispute resolution without concern for geographical restrictions or location, as we provide state-of-the-art hearing room facilities at an affordable cost. Our experience and professional expertise ensures that you will receive an efficient and effective service, hence the reason why the Center was recognized and awarded the Arbitral Institution of the Year Award during the 3rd African Arbitration Association Conference held in Accra, Ghana from 3rd to 5th of November 2022. We also provide training in arbitration and mediation to ensure capacity building of practitioners, including arbitrators and mediators across the globe. Since inception of our training in 2019, NCIA has so conducted over 20 trainings attended by over 150 trainees. With the level of success attained so far, we will maintain the pace to ensure the dispute resolution services that we offer continue to meet internationally benchmarked standards. We will continue to grow and expand our regional and international networks to ensure that we incorporate internationally accepted best practices in alternative dispute resolution mechanisms and practices. There is a likelihood of disputes happening during human interactions, more so in business and commercial related interactions where parties have entered into commercial or trade agreements. At the Nairobi Center of International Arbitration, we have built the capacity to provide support and resolution of such disputes by having a panel of internationally recognized and experienced mediators, arbitrators, and case administration professionals. We welcome you to NCIA, where disputes meet resolution. The Nairobi Center for International Arbitration is located at the heart of Nairobi, one of the most international and vibrant cities in East and Central Africa. The NCIA is easily accessible with its convenient locale in the vicinity of international airports. The center was established in 2013 via an Act of Parliament to facilitate and promote the conduct of international commercial arbitration, as well as alternative dispute resolution mechanisms. The available dispute resolution mechanisms adopted by the NCIA are convenient, quick, independent, and up to international standards. Since the inception of the NCIA arbitration and mediation rules in 2015 to the present, we have provided alternative dispute resolution services. Since its inception in 2016, the Center has seen a steady increase in the referral of disputes under the NCIA arbitration and mediation rules. Currently, the Center has reached a significant milestone of cases referred, marking a notable upward trend over the past 7 years. The case value by the end of December 2022 had risen to 25.25 billion Kenya shillings, equivalent to $210 million. The largest single claim recorded is equivalent to $50 million. NCIA rules provide a state-of-the-art procedural framework for dispute resolution through arbitration and mediation. Over the years, the cases typically anticipated at the NCIA emanate from the construction, supply and delivery, technology, finance and employment sector. In promoting diversity and neutrality, the NCIA has impaneled arbitrators and mediators drawn from different nationalities. The vision of the NCIA is to keep up with technology and modern innovation and to facilitate alternative dispute resolution without concern for geographical restrictions or location, as we provide state-of-the-art hearing room facilities at an affordable cost. Our experience and professional expertise ensures that you will receive an efficient and effective service, hence the reason why the Center was recognized and awarded the Arbitral Institution of the Year Award during the 3rd African Arbitration
Rising out of ISDS and commercial arbitration. I'm honored to welcome you to what I hope will be a concise yet pivotal panel discussion on this topic. In today's interconnected world, foreign investments are the lifeblood of economic growth and development for nations around the globe. In the pursuit of these investments, states and investors alike turn to arbitration as a primary mechanism for resolving disputes. Yet, in recent years, some arbitration awards have emerged as towering giants, casting quite a shadow over the very essence of justice in international law. I'd like you to consider this. The case of Chevron versus Ecuador, which was an ISDS dispute, where an international tribunal awarded Chevron $96 million for alleged treaty violations. But then in a dramatic twist, the same tribunal ordered Chevron to pay $9.5 billion to Ecuador for environmental damage in the Amazon forest. A US court ruled that the $9.5 billion Ecuadorian judgment was the product of fraud and racketeering activity, finding it unenforceable. This finding was upheld on appeal. The lead American lawyer behind that Ecuadorian lawsuit against the company was found to have violated the Racketeer, Influence and Corrupt Organizations Act, commonly known as the RICO Act, committing extortion, money laundering, wire fraud, and being in violation of the FCPA, the Foreign Corrupt Practices Act. Witness tampering, obstruction, as you can see, a host of violations led to the nullification of that award. This case was dubbed the legal fraud of the century. And as you can imagine, the colossal award had the potential to cripple a nation's finances, and it ignited fiery debate over the purpose and proportionality of such arbitration decisions. Take, for example, P&ID versus Nigeria, which was a commercial arbitration. Here, a BVI registered industrial development was initially awarded about $6 billion in a dispute over a gas project. With accumulated interest, this award is now $11 billion worth against Nigeria. There are huge ramifications of these types of awards. Closer to home, we have witnessed the Ntaka Nickel Holdings Limited case versus the state of Tanzania, Republic of Tanzania, where an award was recently issued for $109 million. This was for license expropriations. These real-world examples underscore the gravity of the issue at hand. Crippling awards intended to deter misconduct have raised concerns about the potential chilling effect that they have on states' ability to regulate public interest, attract foreign investment, and protect sovereignty. And so you may sit there and ask, why is this important? It's important because there are underlying questions about balancing sovereignty and investment, striking a balance between protecting the sovereignty of nations and fostering favorable investment climates. There is an impact on public services because invariably, if such high awards are paid, they divert funds from investment in health, in education, and other sectors that might be paramount for most of these nations. There's then the question of investor confidence. The threat of awards of this nature can deter investors and affect nations' economies. Lastly, there is fairness and proportionality. We must examine, and I do hope my panel will examine with you, the question of whether the penalties imposed through arbitration are proportionate to the alleged misconduct and whether these uphold the principles of fairness and justice. Today, there is my panel, which has distinguished experts who will bring you what I can hope you will consider to be unique perspectives. And with this, I'd like to welcome to the stage Kuram Khan, who is a partner at ACH, part of the ALM team based in Dubai. He works closely with Kenya and Pakistan as counsel. His complete profile is on page 23 of the program. Next, I'd like to invite Noella Lugano. She's a partner at Oraro and Company. She's based in Nairobi and has experience as counsel for investors and also acted in asset tracing. A complete profile is on page 35 of the program. I then want to invite James Morgan up to the stage. He's a partner at White & Case in London, developing the firm's presence in East Africa with Kenya as a first port of call. He's English qualified with experience as counsel with a bias in construction claims. His complete profile is on page 20 of the program. Last but not least, we have a non-lawyer, and we are often very happy to have those with us. Rinal Jain. He's a damages expert who's based in India. He's got global experience as an expert in Asia, Australia, Europe, Africa, the Americas. His complete profile is on page 18 of the program. As we embark on this vital conversation, we invite you, our audience, to actively participate by posing questions and sharing any insights you may have on this very vital topic. We have reserved a session, which we will get into at the end of the views that will be expressed by our panelists. And with that, I would want us to get right into it in discussing these very interesting topics of the day. Welcome to my panel. Can you give them a round of applause? Yes, I can see Kuram watching on that side, and therefore I shall move in that direction. Now, as we get started, I would like you as my panelists to share your comments and insights on what we observe as investor-state disputes begin, and also your comments and general oversights on what and how these crippling awards become an issue for investor-states and also parties in commercial arbitration. James, maybe we can start with you.
Yeah, sure, thank you. I think these issues often arise through various means. You obviously mentioned the Tanzania nickel case in your opening, and that's I think a classic example that we often see where there was a change of government policy. In that case, from having a very open mining investment regime to then very much closing it down, changing the licensing rules, stopping any exports of material and claiming basically total sovereignty over the natural resources. Now, that's obviously a state's right to be able to change its policies, but when you've invited investors in and then you make such a drastic change in your policy so quickly, then that can have serious ramifications and lead to significant claims. Obviously, sometimes that happens, as in the Tanzania case, when the government has stayed the same, but another classic example is where the government changes and then brings in a whole change in policy approach, and that can lead to, again, significant changes in investment regime that can lead to significant claims. And then the kind of final one that I would like to briefly touch upon as kind of a cause of some of these claims, and this was highlighted in the White Industries in India case, is states not having in place proper processes to handle large-scale investors. So in that case, the Australian investor had just brought a normal commercial case, had won its claim, and was trying to enforce that through the Indian courts. And it basically just got bogged down in the Indian legal system and got nowhere, and they were completely unable to enforce their award. So they brought a claim against India for a failure to put in place proper protections and proper processes, a proper, effective legal regime that would enable them to enforce their award, and they won the case. So again, I think it's incumbent upon states not only to think about their kind of obvious investment policies around mining, minerals, resources. Often we see a lot of these things coming out of the kind of hotel sector as well, and kind of entertainment and leisure more broadly. So thinking about how all of those things are regulated in a pro-investment way, but then also thinking about the kind of less obvious investment processes like a proper court regime that allows investors to actually actively participate and have awards enforced in the country.
Thank you. Noella, are there more deliberations that states can take when they're contracting?
Yes, I think I'll just start by commenting on what my fellow panelist has said, by taking a bit of a different trajectory as to what scholars say can give rise to crippling awards. So the theory behind it is that the principle of state responsibility requires full reparation for any wrongful damage that is suffered by an investor. Now, the understanding of what full reparation is to, first of all, wipe out that wrong completely, and then revert the investor to the original position he was, or he would have been, but for that breach. I think discussions were had by the International Law Commission as to whether they should qualify this concept of full reparation by allowing states to avoid paying full reparation where it would cripple the economy or socio-economic fabric of the state and its people. But that was rejected. And a number of reasons were put forward as to why you should not qualify this concept of full reparation. One was it was open to abuse, it was very uncertain. Secondly, they said, look, there are various other ways that you can deal with what is considered a crippling award, such as remoteness of damage, exclusion of indirect damages, claims, and among other things. And then I think the biggest argument against qualifying full reparation was that it's very rare that an international tribunal will award excessive damages. That was in the 1950s. As we look at the numbers of the nature of awards that we're seeing, it just keeps growing and growing and growing. And the number of damages that are awarded against states, invariably, because these claims are brought by investors, are now over 100 billion USD. And so that's kind of the context. And then there's the practical aspects of investment treaty law and what goes on behind the scenes, the pre-contracting phase. A lot of the BITs that developing countries signed were motivated by cooperation and committee. So that most of the people who negotiated these agreements were non-lawyers, first of all. So they had no appreciation for the ramifications of breach of these BITs. And they just didn't understand that there was really very little in-house expertise on even understanding how damages are computed and the various valuation methods that would be applied. And I think this has had a knock-on effect in what is arguably an investment environment that is built to protect investors, where the principles of investment treaty law are built around the protection of investors' investment, not necessarily state protection. So I think just to give it some context, that's the context that I would say would then lead on to this knock-on effect of crippling awards, because we just don't have a regime that qualifies this concept of full reparation, which means satisfaction, restitution, compensation, returning me to the position that I was, but for your breach, including the potential profits that I would have made. I think I'll stop there.
So much, Noella. I think that definitely casts some context for the audience members. And it allows me to then bring you in. We're talking about the pre-dispute stage, we're talking about the pre-contracting phase or the contracting phase as well. And in this phase, do you see that there's need for there to be advice, expert advice at the beginning of all these contracts?
Sure, thank you. A very good morning to all of you. In my view, it makes a lot of sense for experts to advise the transaction lawyers at the contracting stage, or even in the bilateral investment treaties, it is very helpful to include some of the clauses that would either reduce the possibility of disputes, or if at all a dispute occurs, would result in an amicable and an efficient way of resolving them. One example is, and which actually relates to the point that Ncia mentioned on full reparation principle, is the valuation standard. Often I've seen in contracts, lawyers clearly stipulate the valuation standard that would be applicable in case of a dispute. Even in investment treaties between certain countries, it's very well stipulated that a fair market value standard would be applicable, which is very different from the full reparation principle that Noella just mentioned. Because under the fair market value standard, you consider a market participant view. You do not consider an investment value standard where you're trying to make the investor whole. So that sort of has implications from an economic and financial standpoint on what would be the value of compensation at the end. But this is one example of how choosing a valuation standard can ultimately impact the value of the compensation if and when the dispute arises. Some of the other clauses that are actually relevant at the contracting stage would be defining the exit price well in advance. I've often seen various clauses where it's clearly stipulated that in case of a dispute, the exit price or damages would be a multiple of your past 3 years average earnings, or could be a stipulated defined return over the investment that has been made. Now, obviously these are highly contentious, this can be very subjective, and you definitely require a lot of analysis and due diligence before any such clauses can be introduced. But in various cases on the exit side or otherwise on commercial dispute side, where I've seen such clauses being included at the contractual stage, it results in narrowing down the differences between the two parties. Another third example is exclusionary clauses. Almost everywhere I see in these contracts a clause that would prohibit either party from claiming consequential or indirect losses or loss of future profits. Now, it's actually worth thinking when we're drafting this clause whether we can include some exceptions to this clause. And I've seen this very commonly under English law as well. Sometimes you do have these exclusionary clauses with an exception of fraud and misrepresentation, with an exception of mismanagement of operations. And it's a double-edged sword. I'm not saying that ultimately whether it's going to benefit one party over another, but at least it allows parties to use advantage of that clause, and if there is an actual case of mismanagement or misoperations, then you can still have these losses such as loss of future profits. One last point I would like to make is on the date of valuation. Now the date of valuation, especially in cases of investor-state disputes, becomes very, very contentious. In the light of the fact that principally, investor can choose the date of valuation to be the date of expropriation or date of award, whichever results in a higher value of compensation. Now again, if something around this could be defined at the contracting stage itself, might help reduce differences. If not, I know as experts we have worked with councils where we have seen a very wide difference in the value of compensation in the two dates. UCOS versus Russia is a classic example where the difference in compensation at the stage of expropriation versus at the stage of award, the delta was $44 billion. I'm just talking about the delta, not the value of compensation. So these are some of the factors that have a very significant economic and financial consequence on the value of compensation, and if thought through, might help in either mitigating or reducing the possibility of disputes or resolving them more effectively. Thank you.
Thank you, Rena. And Kuram, let me bring that question in a different way for you. I think in many ISDS there is in some commercial arbitration agreements, for some reason we do not see much use of the escalation clauses. Do you think that these would also be important to consider at the contracting phase? Because we then witnessed a number of states trying to negotiate post-rendering of these substantial awards.
Thanks. I have to say I was expecting to answer a different question, so I have to pivot quickly. So I think with the escalation clauses, it's a bit double-edged in that it's certainly helpful in some cases to have a tiered approach for a couple of reasons. One is that it often allows a cooling off period, and it gives parties a chance to take stock, consider their legal positions, consider the appetite for a formal dispute. And that's, I think, quite important. And then as you go through the steps, as we know, there's many permutations on that. I think one challenge is that if it's not carefully thought through, the escalation often doesn't work out the way that the parties, or at least one party, envisaged. And so that procedure at the early stage can go a bit awry. It also often results in gamesmanship where one party is trying to exploit that escalation clause and can slow down proceedings unnecessarily. And I think in my experience, and I'd be happy to get the views of my panelists, tribunals more and more have taken what I consider a practical, substance-based approach and less formalistic, and to try to determine whether the various steps have been ticked off there. So I'd say, to recap, it's quite an important piece, especially for ISDS scenarios, but it does need to be considered quite carefully. And I think it ties into some of the points that Noella and the colleagues said, which include the ability, let's say on the state side, for instance, to be able to contract the way that it wants, to be able to devote the resources required on the transactional side. And I think that's a gap actually that we often find. This applies to investment disputes. It also applies to straight commercial business-to-business disputes where transactional lawyers are focused on the deal, and they often don't consult us on the back end of that, and that can sometimes cause problems.
Thank you for that. And I think we often feel left out of those rooms as disputes lawyers, where we're just cleaning up the mess and not really participating in the solution generation, or kind of projecting what would happen if things go wrong. But I think money men don't want to hear that conversation up front. So then, Noella, let me bring you into this and ask whether there is a pattern based on some of the cases you've been involved with and are aware of, where there's some form of crystallization of issues that begin the disputes, and also how some of those can be litigated based on what we've seen happen.
Yeah, so I think I'll try and contextualize this from the perspective of a crippling award. So I think if you look at some of the cases that gave rise to disputes, you see they're caused by the state not meeting some of its obligations insofar as the investment is concerned. If you look at the Nigerian case, obviously the state of Nigeria was supposed to put in place an infrastructure that would then allow the investor to exhaust his investment. They didn't do that. It's not explained very well why the state didn't do that. If you look at the Peruvian case, you see that the reason was the state did not create an environment where the local people were then receptive for the investment. And so I think there are certain discussions that need to be had when states allow investors to come with certain legitimate expectations, and then a government changes and it has a new policy or is taking a new direction and doesn't prioritize this investment. So a lot of the cases that arise seem to be based on the fact that we have invested, we've come up with plans, we're ready to now develop this investment, that we have done exploratory work, we've gotten experts and consultants, but then the license is either withdrawn or you're not given a license. And so there's some sunk costs in that. And so when you look at that in the context of a crippling award, what we see tribunals doing is they fail to recognize that there is no built-in event. You haven't yet built your investment in terms of brick and mortar, but you have done some exploratory work, which is expensive. It can be up to 40 million USD. But when they compute damages, they take you back to make you whole as if you had built the investment and were going to make profit for 50 years on this license. So that you have a 40 million investment, but you have a 6.6B award. And I think that is problematic. And I think tribunals maybe need to start thinking a bit creatively, and also litigants, the lawyers that represent the state, as to how they can deal with this issue. Because what the statistics show is states don't raise issues of the crippling nature of the award that is likely to be made against them. They don't consider that a viable argument to make before the arbitrator. That's one of the things. The other thing is tribunals don't consider an obligation for them to think of proportionality of the award. They consider that something that will be relevant at execution, and it's not their problem. They also don't consider past precedents, such as, when you look at the awards that arise from World War II, you do see built-in provisions that recognize that if we were to apply full reparation against Germany, it would not be able to meet that. And they do recognize that in Article, I think, 231 of the Versailles Agreement. And you also see some human rights courts recognizing that where an award is such that it deprives the state of the ability to take care of its people, whether by way of their welfare, their education, and their, just their subsistence, then that's a human right abuse, and really it shouldn't be enforced. And so I think what needs to happen is we need to be bold enough to make some of these arguments before the tribunal. It's just that the statistics show no one makes these arguments. No one says this award will result in a human right violation. That there is precedent to show that where a state cannot meet this award, then it shouldn't be awarded. That proportionality is a recognized principle that you should think about. So I think there's a lot in there that we probably need to start thinking about, even though international law as we understand it and investment treaty law as we understand it has not yet embraced a qualification, and a customary law qualification on full reparation. So I think I'll just stop there.
And James, let me bring you in now. What do you think, based on what's been said, states could do different? Because it does seem like there's a bit of critique and a criticism there of how states conduct themselves in the process of arbitration.
Yeah, no, absolutely. I mean, looking at the arbitration itself and the process of that, I think it is, and we see this with particularly the crippling awards that we see, is tribunals saying that the state has often completely failed to make its case, possibly on numerous grounds. So it could be that they haven't produced necessary evidence of their own arguments that they're making. They haven't properly challenged, this is where it now comes in, but haven't properly challenged the expert quantum evidence from the claimants to say that, if you adjust this variable, then there's a huge difference. And so I think it really is incumbent on the states at the arbitration stage to really make sure that they have thought through proper representation and proper making of those arguments. Because, yes, arbitration can be an expensive process, something that's been discussed over the last few days, but actually you can save money through properly arguing your case. If we're talking hundreds of millions of dollars, billions of dollars, then if you make good legal arguments, good expert arguments, and properly invest at that stage, then actually you're going to save way more in terms of what the final award is by actually engaging and properly defending those points. And then I just also briefly wanted to pick up on something that Noella said as well, about how a lot of these things come up because maybe the initial investments haven't been made by the state. And I think, again, this is obviously something before the arbitration arrives, but some actual proper screening of investments, not only from the investor side, because going back to the Nigeria PMID case, I think there's a lot to be said for, even if Nigeria had done its bit, the investor who had like no assets and no expertise in the oil and gas sector that they were meant to be investing in, that's not a proper investor. So you need to firstly screen your investor, but you also need to screen your own processes and think, if we are promising the investor that we will do X, Y, and Z to enable its investment, have we got the necessary, I don't know, maybe it's skills, or maybe it's legislation, or maybe it's contracts with contractors, because you need to build some infrastructure first. Are they already in place? Are you able to make sure that you can fulfill your side of the bargain, to make sure that you don't get in a position where the investor's hardly done anything and is then claiming billions of dollars from you?
Thank you so much for that, James. And Kuram, any observations or comments on this particular issue based on your experience?
Sure. I think to just take a step back, for the states, for instance, if we take that context, there are a number of considerations that then downstream, say 3 years on or 5 years on, could result in disputes, and it's worth taking stock of that. So for instance, there are many exit cases, including the ones that Noella and James mentioned. There's also the case, the Pakistan case against Karki. There's also the Pakistan case in the mining context, Rico Deep case, where clearly at the provincial level and at the federal level, there was not a good job of really understanding what the transaction was meant to be. There's not a good job that was done in terms of understanding what revenue streams would go to which government agencies or government departments or the people. The other practical side of this that I think often comes up is when states are contracting, there are many stakeholders, right? So often you can have a Ministry of Energy that's consulted, you can have the relevant regulator, or you can have the Department of Public Projects, but you can sometimes have a state security apparatus that also needs to weigh in. And that sometimes results not only in a difference of views, but also a limited amount of resources that can be put towards that deal side. And then down the road, that can, as I said earlier, result in disputes. So I think that theme runs through a lot of the cases that we're talking about, that at the early stage, there's not that much opportunity perhaps, or let's say thought that's been given to what problems could arise. And then on the back end of that, there are many problems, and parties are less scrambling for solutions at that stage.
Add something?
I just wanted to add something on the Pakistan case that you mentioned about copper mining. So the criticisms to that case, it issued an award of 5.9 billion USD on an investment of 40 million USD. And the first thing they say is, the arbitrators blatantly ignored allegations of corruption that had been raised. That was one of the first problems. They were reluctant, and this happens in some arbitral tribunals, where they'll be reluctant to address some criminal nature issues because of first of all, they feel that they're not experienced in that area. The standard of proof is quite high. It's just, it's foreign territory. So they will be reluctant to impute corruption, but clear corruption allegations were made. They weren't considered, they were dismissed. The other thing that the tribunal refused to regard was the fact that there was illegality in how that investment had been awarded. It wasn't in compliance with domestic law. But the tribunal disregarded this under an international law principle. I forget which one, but that was one of the criticisms of that. And then over and above that, remember we said the investment was on the pre-planning stage, the preparatory stage. So nothing had been done. There'd only been exploration, there was no inbuilt investment. But in contrast to the Peruvian case of, it's called Bear Creek, where they only awarded sunk-in costs, so the cost of the investment, and found that no compelling evidence had been produced to show the potential of making profit across a 50-year license period. In the Pakistani case, they did that. Then they compounded the interest when they awarded, and then they awarded very high legal costs. Now, when you put all that together, what you have is an award that was the equivalent of an IMF loan that had been granted to Pakistan because it was at that point at that point in time in a very socio-economic, it had socio-economic complex. So will you pay the loan or will you pay this award? And that I think is the concern. So that particular decision had about 5 or 6 inherent problems with it, not to mention the impact that it would have on the people of Pakistan at that particular time.
Yeah, Noelle is completely right. And then it also had the further complexity that there was infighting, if I can call it, within the various government entities, and there's a federal versus provincial side to this. So there's many layers to that, and sometimes the outcome for the state can be unfortunate. I have to say that one thing that's interesting is that in that case there is a new sort of a second chapter, which is a transactional resolution where there is continuing mining operations under a deal that's been made by reference to the award. And that can sometimes also happen.
Yeah. Now, I think Noella has taken us into a territory that we cannot avoid discussing, especially given the nature of what we are talking about here. And so now maybe I can ask you first, and James, I'll definitely want your comment on this. The regard or place or consideration of malpractice, whether we call it corrupt practice, subversion of domestic law, when this is at play on the international landscape. Any comments or observations based on what you've seen at play at this international forum?
It's an interesting point to note, especially in international arbitration, where we're dealing with, say, an underdeveloped or a developing economy where a parallel black economy exists. It becomes very challenging to assess the real value of the compensation, because what you see on paper is very different from what actually has gone into the investment or what has gone into fulfilling the obligations. And in those scenarios, I think the best you can do is point out towards the market inefficiencies, and we've done that in several expert reports where we realize that the market is opaque, there is lack of information availability, where we are dependent on the local experts, sometimes on some confidential information. The assessment of compensation there becomes very challenging, subject to these factors. So I think as an independent, unbiased expert, my duty is to let the tribunal know that what are these market inefficiencies that exist, and therefore any assessment of compensation is subject to those factors. So as an expert, that's the best I can do. Educate the tribunal about the factors, the economy, about the local situations that is impacting the valuation analysis, and then it's ultimately their decision. I'm not sure if James, you agree with that.
Yeah, no, I do agree. I mean, I think you do need to take all of those facts into consideration when looking at the quantification for them. I think there's also a point to be made about, before you even get to that, the quantification, that, you know, there needs to be a proper consideration of these sometimes very, very serious fraud, bribery allegations. Again, Nigeria being is an example of that. We've now had earlier this year like an 8-day trial considering in the UK courts, considering just those bribery allegations with new evidence and everything else, and we are awaiting the judgment on that. But there does need to be a proper forum for consideration of those. And there was a Supreme Court judgment in the UK that has literally come out this week, and so I haven't read it yet, but where the Supreme Court said bribery allegations raised by Mozambique should be tried in court and not through arbitration, because the arbitration clauses in the contract were not, those contracts and the arguments made by the investor that they were on a commercial basis. That's not a defence for whether a bribery took place to make sure you got those contracts even if they were on a commercial basis. So arbitration is not always, as Noella said, the best place for those issues to be tested. And I think we do need to consider more broadly across the international community how best we deal with those and at what stage. Because you get the Nigerian PNID case, it's already now, 11 billion, maybe with more interest that's accruing even today, it's 12 billion now, who knows. It's a very large number. You already have that award. And only now are we getting the discussion of the bribery allegations. And there needs to be a better way of doing that.
Thank you for that. And there's a comment that Kuram then made, which I want to pick up from, which is, despite this conversation about what's happened in the Pakistani case, there is an attempt to resolve this outside of the tribunal forum. Now, whether that then has an impact on investor confidence, whether that then has an impact on a nation's confidence in its own processes and systems, the transparency that one expects out of these dealings. I don't know whether you might have a comment on the place of whether this action should be sanitizing, action that we're saying we should potentially have a view on one or another.
Yeah, sure. So you're seeing a bit of a trend, and I can't speak authoritatively to this, of states resisting to pay these crippling awards. So not only are they resisting to pay these crippling awards, but they are also passing legislation that ensure that they're not enforceable in those states. And then the third step is they're withdrawing from these BITs or threatening to withdraw from these BITs. So that's one sort of very extreme reaction, and you'll see some East African countries adopting that kind of strategy. But then you see Pakistan taking a very different strategy, where it tells the investor, look, we can't afford to pay you this award, but we think we can still do this project with you, and so let's see how we can, instead of paying you the award, involve you in execution of this project. So it's very innovative, I think, and so I don't think the solution lies in any extreme. It probably lies in a bit of a middle ground, because I don't think we can say that in this time and era, states are islands and do not need to enter into agreements to trade. I think we all need each other. So I don't think it would be the correct course to post the fact, pass laws that undermine an arbitral award, or withdraw unilaterally from BITs just because you're unhappy. Justifiably so, because it is a crippling award and it affects your economy and you're a politician, so you must play to the gallery. But I think an in-between solution, such as the Pakistani one, is the way to go. And I just want, before I close, I just want to comment on the Nigerian case. So when I read the Nigerian case, of course I had a very theoretical view about crippling awards. So this is driven by computations done by my colleague over there, and valuations done by them, compounded interest, very strict interpretations of full reparation, all those very theoretical things. But I invite you, if you sit down, it's a public document, and you read the Nigerian case, the award, you see it's got nothing to do with those things. So there's always a period, and then there is what happened in practice. You will see maybe some instances where we as lawyers representing states should or ought to have been a bit more robust in how we went about it. So that we then leave the tribunal with no other option than to find against you on the basis of the evidence of the investor. So this coupled with the fabric of international investment treaty law, which favors investors, you know, it just leaves Nigeria in that very same position that it is. So I think there's a lot to be said about how we as lawyers, the lawyers in the room, represent our clients before these tribunals, the kind of lack of thoroughness. You know, there's a default judgment somewhere for enforcement which was undefended. There are a lot of allegations that were made that were not rebutted. So I think that was what came into play. Quite apart from the corruption issues, there was a lack of robustness, I think, in my view, in how that case was handled.
Yeah. James, you've got a reaction to
Noella's
comment?
It was actually not the last bit, but something that Noella was saying to start with about you know, the approach to kind of trying to withdraw from the IT states. I think, you know, the example of Argentina trying to kind of almost enforcement proof itself against, you know, the very famous awards that have been issued against it for many billions of dollars, has shown that, you know, trying to withdraw from the global trade system, from the global finance system, is not good for you. It will have massively damaging impacts upon your country and your economy. You know, unless you are a North Korea, it's very, very difficult to isolate yourself. And even then, the results generally aren't very good. So I think we need to discourage that. I've been involved in the settling of was just pre-award, but it was the hearing had taken place. It was very obvious that as the investor, in that case, we were going to win. It wouldn't have been crippling, but it would have been a reasonably large award. And rather than go through with that process of having an award against it, having to consider what options it might have in terms of enforcement, do we try and withdraw from some of these global systems? You know, the state came back and renegotiated the contract. We renegotiated the investment successfully, and that project has now finished and was successful. And you know, a lot of the time that was a change in government that had brought with that about, and it's just about sitting down sensibly and discussing some of these things and going, come on, this doesn't need to happen. We want this thing to happen. The state wants it because it's good infrastructure. The investor wants it because it's already put some people, equipment on the ground. It wants to be able to use those now to generate profit. So how can we come together and avoid these problems? And I think, you know, that is something that needs to be looked at much more. And you know, obviously the Pakistan case is something a bit more public. This was all pre-award, so it was never a public thing. But yeah, making those changes in how the investment is structured to make, you know, the new government or the investors happy with the new outcome. I think that's just a sensible way around a lot of these issues that we're talking about today.
Now that you've got the mic up, you want to react to something?
Yeah, just a point that Noella raised about how councils approach towards these cases, and she's absolutely right. There are several exit cases in the past where I've seen in cases of unlawful expropriations, councils taking a very aggressive view. At the same time, some councils taking a very reasonable view. Just for example, the valuation standard that I talked about initially, although you can still principally argue for full reparation, in a couple of exit cases where I was involved, councils took a very reasonable approach and said they instructed me to calculate compensation under the fair market value approach, which results in a much more reasonable value of compensation because you're taking into account the market participant view, the industry view to calculate the compensation and not the full reparation principle. Whereas in some of the other cases, I've taken councils taking a very aggressive view where they will instruct me that they want to go ahead with an investment value standard, not a fair market value standard. So in a fair, just for the benefit of the audience here, in a fair market value standard, you do not take into account any buyer or claimant or respondent specific synergies. It's an absolute market participant view. Whereas under full reparation principle or an investment value standard, you're allowed to take the investor specific synergies. which might result in a very high value of compensation. So it really depends on what is the pleaded position of the councils, to what extent they want to go out and still argue for reparation under unlawful expropriation.
Any observations on your part?
So I would echo what my panelists have said. I think a couple of so one point that Noella mentioned, which I agree with, is that states across the board, but particularly in Africa, have been thinking about whether to change the ISDS regimes. So this has come up in Southern Africa, among the SADC states. It's also come up in conversation in West Africa, and we'll see how that develops. But I suppose that's one part of the equation, whether that regime can be revised to be more favorable or from the standpoint of the state's balance. The other side, of course, also is what is it essentially for states that are contracting, what rules are they playing by, what approach are they taking to, again, the transaction side of something, and the interests of their people. And then the one other thing I was going to quickly comment on is among the various exit cases, the extent to which a negative award can be converted into some form of negotiation to get a project going depends somewhat on the type of project it is. So a hydro project might be a very different animal than, let's say, a mining project where there's quite a clear runway to how revenue would be seen or investment will be recouped.
Thank you. Now, we've all had that there are many players in this realm of arbitration. We've got the claimants, we've got the respondents, we've got the tribunal, and we definitely have the experts on board. We are then going to go into a bit of a debate about which of those actors plays what role and how efficient or inefficiencies from them can impact the process. So I'm going to start with James, who will tell us about the critical role of claimants in the process of arbitration.
Thank you. For me, claimants are the key players in this process. They are the ones that really set the pace and the shape of the dispute. They're the party that's been wronged, and they're the ones who are seeking recompense. So the claimant really dictates what the dispute is about when it comes to arbitration, and also, as Manal has helpfully made my case for me a couple of times already, it helps to set the quantum limitations of the dispute. So, really, I think it is the claimants that drive the whole process. In part by setting the tone for kind of the complexity and the issues that need to be considered by the tribunal, by the respondent. And obviously, in terms of kind of crippling awards, as Manal said, the claimants really set the tone there and set the approach. What valuation method are you going to go for? Are you going to go all in and claim as much as possible? Are you going to perhaps take a more reasonable approach and try and go for a claim that's maybe on a maybe slightly sounder legal or expert basis but gives you a smaller quantum? That is a decision that is made strategically by the claimants, and that then drives everything else that comes. For me, it is definitely the claimants that are behind this process, who are pushing it forward, who are pushing often the limits of what's previously been the norm. As Noella was saying at the start, when this whole system was founded, the crippling awards weren't seen as an issue. They've become an issue because claimants have been clever. Claimants have been innovative in coming up with new arguments in new ways to seek to increase the quantum that they might be able to get out of this at the end of the day.
Noema, tell us then, what is the role of the respondent to rebut everything that the claimant brings to the plate?
So the respondent is ordinarily a state. So obviously in that capacity, it represents not individual interests, but the interest of an entire citizenry. So to my mind, they are the drivers of the arbitration. More particularly because the investment is being made in the host state for the benefit of the citizens of the host state. And that should be the basis by which we start this sort of proposition. How do they drive this arbitration? They have to have done that even before they get into that dispute. So from the very onset, when they agree or they negotiate this investment, obviously they have to have the right people equipped with the right expertise, and they need to be innovative. They need to think of all those clauses that Minral had mentioned, whether you can have limitations of liabilities, whether you can have fair market value, whether you can have a cap on liquidated damages, whether you can have those in there. It's a negotiation. And it shouldn't be on the basis of committee and cooperation, and you just need to get this done. So they do drive the process even before the dispute arises. So the second role they play is during the arbitration, you need to choose your counsel very carefully. Who you choose to represent determines largely who you choose to represent the state largely determines the outcome. And you've seen states with 12, 11 international arbitration awards successful against them. Then you have Kenya, which is always successful in international arbitration. So I think there is something to look into there. How are the legal teams structured? Is it a hybrid? Are they comprised fully from the AG's office, local lawyers, or is it a bit of a mix, or are they exclusively ILFs? I think representation is a big factor, and then the expertise of the expert witnesses, I think that's the other thing that you need to look at. But I think more importantly, you drive this arbitration as a respondent if you're bold enough to make innovative arguments. Arguments that rely on, human rights as one of the sort of like arguments you can use to defend this award. Say that, look, this will constitute a breach of socio-economic rights in Kenya, which are now recognized in our constitution. The right to health care, the right to housing, all those are rights that are protected in our constitution. And if you pass this award against us, our constitution is supreme. We will not enforce it on public policy grounds. So I think we need to be bold enough to be able to make these very robust arguments. Whether they fall on the wayside, it doesn't matter, but you've given it your best shot. And then to think innovatively at the point of enforcement as to whether you can challenge this award on the basis of public policy, or should you be doing what Pakistan did? Should you be sitting down and saying, okay, it's a bad award, we should be negotiating? And should you be pushing the tribunal to then consider things as this contract is tainted by illegality, it's tainted by corruption, things like those. You need to be able to bring those out so that then, and you're also pushing them to say, look, this is a briefcase investor. Under no circumstances is this an unexperienced investor going to make profit worth 6.6B if he gets his license for 6 years. The mere fact that he has a license, it doesn't follow that he will make the profit that is projected. So I think we just need to be bold enough, we need to be innovative enough, but I think it's driven entirely by the state. It has a greater interest in this project. It represents a wider interest than an individualistic interest of the investor. And so I'll beg to differ.
Yes, I should have asked at the beginning that you bear in mind these arguments, because I will ask which side you think takes the day. So we've now heard from the claimant, a very important party, and the respondent has made quite a case for its position within the arbitration setting. Now we then have experts, and Rina will let us know why they navigate this process more deftly.
Sure, thank you. In my strong opinion, the most critical role to be played in the entire arbitration is the role of an economic damages and valuation expert. And I will prove that to the audience here in a few moments. Now, I'm sure all of you believe that cash is the king. Ultimately, it's the damages, it's the claim that we're talking about. In all the conversations that I've heard from the three lawyers present on the podium here, from my panelists here, they've been giving examples of millions and billions of dollars. Everything boils down to cash. What is the value of the compensation? Let me now start discussing what James and Noella said. James is an excellent claimant investor counsel. He puts forward an excellent strategy, wins on liability. If he doesn't hire the right expert, that is me. And if he doesn't hire the right expert, and I don't convince the counsel, the arbitrators, on the value of compensation, and he gets a value of compensation for the investors which is close to zero, how does it help? Right? Now let's go to Noella. Fantastic lawyer representing the state, defending all the arguments, okay? Now even if she loses the matter, but she hires the right expert, that is me, in rebutting the claim put forward by James, I can actually, if I have the right contemporaneous evidence, I can actually convince the arbitrators that the value of compensation is close to nil. So she might lose on behalf of the state, but still there is no implications on the value of compensation. And ultimately, I'm sure the arbitrator here would agree with me that my role and the overriding duty is to it's credible and it's reliable. So it's my duty as the expert to use contemporaneous evidences, to rely on relevant market information, and to justify that the assumptions in the business plan are reasonable, and therefore the entire but-for or counterfactual scenario that I'm substantiating represents the loss of the investor. So I would just like to reiterate the critical role that economic damages and valuation experts play, and I look forward to a positive voting in my favor. Thank you.
Thank you so much, and now the tribunal, it holds the pen. So let's hear from Kuram as to the critical role the tribunal plays in this process.
Yeah, I think you said it all, it holds the pen. So the tribunal obviously plays an important role. We often think in terms of a tribunal's ruling on the merits or other substance issues, but often it starts with important aspects of the procedure. And I think a lot of strategy goes into the procedural aspects before we even get into the more substantive issues. Skilled counsel know how to play to the strengths there, whether that means slowing down proceedings, whether it means sometimes dilatory tactics, whether it means a certain, in the case of commercial arbitration, a certain type of procedure. And then for the tribunal, it's important to recognize what's going on. What are the games that are being played, and what's allowed and what's not allowed. So it's crucially important that the tribunal is able to direct the parties within the scope of their mandate. In many respects, but I'd say starting on the procedure side. The other, obviously very important aspect is that a tribunal must ensure that the opportunity to be heard has been provided to both parties or to all parties. And this is something that I think gives to good tribunals, there's a lot of anxiety that results from this consideration, rightfully so. I think one other part of this that is sometimes a little bit unfortunate is that although fairness and due process considerations are very important, tribunals do get concerned about whether they will issue an award that might be set aside or might be viewed poorly. And I think that is something that is that much more, provides that more reason for parties to choose competent counsel, experienced counsel, rather tribunal members to preside over that dispute. And then one other point I'll make is that because international arbitrations, whether they're commercial or we're talking investment treaty disputes, tend to be complex and multi-layered. You can have parties, obviously from different countries, you can have different legal systems involved. The tribunals are diverse, and tribunals are human beings at the end of the day. And so what their factory settings are is crucial, and it's really important for counsel to understand what makes them tick and how they might approach certain issues. But then that brings it back to the fact that the tribunal wields extraordinary power in these situations. And then finally, I'll say that on our expert, on Mrinal's point, certainly it's the case that the expert has that role of pointing out to the tribunal what certain issues, or say in the case of quantum, or it can be valuation issues, what those figures need to look like, right? So are you taking, first of all, what's the right approach to be taken? Are we looking at something from a discounted cash flow standpoint? Are we looking at something from an enterprise standpoint? And so on. But ultimately it does come back down to the tribunal to take a view on which methodology is appropriate and the extent to which the computations seem reasonable between the various experts. So at the end of the day, it's I think it goes without saying that it's a crucial role, and we have to be careful of our tribunals.
All right, then. So to the audience, then I'll ask by a show of hands, how many of us think the claimants navigate this process of international and commercial arbitration? Show of hands. The claimant, more than the notice, is the investor. Oh my God, James, do you need the right of rebuttal? Okay. The respondent, usually the state. Anybody? Ooh, Noella. Well, I think it's because you willed the location of the resource. And how many think it's the experts? The experts who determine what happens here. Okay. And the tribunal? How many think the tribunal determines? Okay. So I think it's kind of looking like the respondent. Yes, James, you want to...
I think the only conclusion we come from that is that nobody likes investors. Perhaps is deserved, so I won't take it too personally. But yeah.
All right. Thank you for that. I then want us to segue, and I am mindful, and I will be looking at the time shortly to see how much time we've got left. There's then the question of what Mrinal has raised. Money, and cash being king. So for many of us in the room, I think a number of us will have legal backgrounds, and there's then the principal question of whether we understand how to navigate the question of damages, whether we make good and compelling arguments when it comes to the realm of damages. And so with that, I want to invite Mrinal to share with us some information on his observations in damages computations, and the considerations and factors that are borne in mind when these computations are being done.
Sure. Thank you. I think I just stepped down the podium because I need to look at some of the slides. Ezra, can you move to, yes, next slide, please. Next. Yes, the next one. Okay. So this slide basically, let me start by discussing what are the factors or considerations that affect the award given by the tribunals on the compensation. Now, I have categorized these factors under two heads. First is the investment-related factors, and second is valuation-related factors, which are more technical, as Corinne mentioned. The tribunal then ultimately need to decide which is the valuation approach to be used, whether multiples, whether income, etc., etc. So on the investment-related factors, the stage of the dispute makes a lot of difference. Sunk cost, the term that Noella used, becomes very relevant. What is the stage at which the dispute arose? Is it an early stage dispute where there is insignificant sunk cost that has been incurred, there is no history of operations, the license has just been awarded, In those kind of cases where even the construction is not commenced or the construction is not even completed, it is difficult for the tribunal to consider a loss of profits or billions of dollars of value in compensation. So in those scenarios, generally tribunals tend to avoid the sunk cost or a multiple of sunk cost just to compensate the investors for the time value of money component as well as the opportunity cost of the capital that has been incurred. Second factor is the investor due diligence, the quality of contemporaneous evidence. That's a key factor. Whenever we assess compensation, the starting point for us is there contemporaneous evidence available that suggests the investor's expectation at the time of making the investment and not exposed after the breach has happened. So contemporaneous evidence and the quality of that again becomes a relevant factor. Stage or operating history of the investor. It's absolutely essential to substantiate to the arbitrators what is the operating history, whether the investor historically had the capability of generating profits, and if yes, what level of profits. So we can then substantiate that in future, the investor would have generated those level of profits, but for the breach or but for the wrongful expropriation. The regulatory framework, I think my panelists have covered enough on the ambiguities around the regulatory framework, which can result in disputes and ultimately the value of compensation. On the valuation-related factors, the biggest question, which is most challenging, is which valuation approach to use. Is it income? Is it market? Is it cost? These become very relevant considerations. And the answer to that is no black and white. It depends on the facts of the case, the availability of contemporaneous documents. It depends on the legally pleaded positions of the counsels. If Noella or if James is arguing on behalf of investors for full reparation, I may rely on the business plan that the investor had prepared at the time of making investment, which might be very impressive, but that doesn't represent the full reparation principle. But if he's arguing it's the fair market value standard, I might rely on a market approach, taking more into account the market participant view. It's important to use as many methods as possible to convince the arbitrators that even if I use more than one method of valuation, my value of compensation is more or less in the same range. We can triangulate our conclusions using transaction multiples, as Kura mentioned, EBITDA multiples, but we need to give supporting evidence in terms of these transactions to substantiate our conclusions. Conservative elements, as I said earlier, when we're dealing with business plan, we need to explain to the tribunal what is our view, why these assumptions are reasonable, they're reliable, and they're credible. Financing should not be a concern. Financing has been a critical issue in evaluating whether the damage or claim should be awarded or not by the tribunals. In at least 2 exit cases, financing has been raised as a major concern by the state. And the state's argument is that you, the investor, would not have been able to complete its obligations because no way it would have been able to raise the funds that were required for the investment. Okay? And then, of course, the regulatory environment that affects the award with respect to the damages. Can we move on to the next slide, please? How damages are generally computed. Next slide, please. Okay, quickly.
Sorry, before you do, James, did you want to react to those methodologies?
I mean, yeah, absolutely. I mean, I think the methodology is obviously really crucial, and we've all kind of talked about this full compensation principle and what does that mean, should we be using it. As Manel was saying, I think it's really important to actually consider the evidence, not just kind of let's go with a discounted cash flow model, let's expand out profits over years, decades. You need to think about what's actually happened. You need to think about what stage the project's at. Is it appropriate to use DCF? I mean, we've talked about Nigerian PNID. DCF should never have been used in that case. There was no investment made at all. There was nothing built. So we do need to give more careful consideration to those issues. I think some tribunals don't understand the intricacies of the different valuation approaches and kind of get lost. And tribunals see DCF being used more and more, and they think, oh, well, that's the right approach, we'll just use that. But you need to properly consider what is correct at the right time. You need more consideration of the maturity of the project, whether you've actually got any financing in place, whether you've actually generated any profits from this thing. You know, what is the market like? What risk factors do you need to put into play? So even if you are using DCF, I think that there needs to be a greater rigour from tribunals in considering what is the proper way of doing this that actually takes into account the different approaches, the different risks that are involved.
Completely agree with that, and my request to all four panelists, please chip in on some of these points because they're all economic and financial perspectives.
Yes. I think I just want to say one thing. Do a site visit. I actually don't want to say more than that. There's nothing more compelling or persuasive than an empty site. So do a site visit, take the tribunal there, tell them this is a claim for an investment for God knows what, wind power, geothermal, and go to the site. And then take them there and see, this is the site. Compare it against this very elaborate report that has been produced of all the things that the investor has said that he has done. So I think I just want to stop there. It's a very small point, very obvious point, but it never comes to our minds because we're used to sitting in offices. We're not used to going on a helicopter over a site in Wajir or wherever to see that oil block. What does it look like?
And with that, actually, because an acronym was used, Rinaldo, I'd like you to explain that acronym to our audience to see it.
Sure, absolutely. So these, actually I can move on to the slide and then come back to this one. Ezra, can we have the slides, please? If you move on to next. Yes. So I know the panelists have used the terms like market approach, DCF, etc. What are these valuation methods that we're really talking about? This slide actually summarizes it all. Globally, these are the only 3 approaches of valuation that are accepted by the arbitrators. There's nothing outside of it. So my humble request to all the councils, when you deal with the experts, please request them not to use very high technical terms. Because when they do that, I don't understand it, councils don't understand it, the arbitrators are definitely not going to understand it. Keep it simple, it's just income market and cost approach. Within these approaches, you may have different variants or methods of valuation, but they all ultimately represent the same fundamental approach. So when I say income approach, it means the company is valued based on the future income potential of the business, discounted back to the date of breach. Discounted cash flow method is the most popular method being used under the income approach to calculate the future potential of the business or the company or the license which is being expropriated. And that is why often we refer to that as DCF method. Market approach, you simply value the company by giving reference to the closely comparable companies that are publicly listed. And when you have these publicly listed companies, their stock prices, which is a fantastic indicator of the market value of those companies, are relied upon by the arbitrators. So we can calculate ratios or multiples using those stock prices, like price to earning ratio, enterprise value to revenue, enterprise value to EBITDA. I've been involved in some of the mining cases where the construction of the mine has not even started. So how do you value them using market approach? So what we've done is, for example, if it's a gold mine case, we can actually look at publicly listed gold mining companies, calculate the ratio of value per ounce of gold resource, and then apply that ratio on your company to get the future potential value. So sometimes the value is not on the extreme ends, where it's not the sunk cost, it's not those billions of dollars that we use using discounted cash flow method, but it's more reasonable somewhere in between, which can be determined using the market approach. And finally, it's the cost approach, which is hardly used by the experts or relied upon by the arbitrators, because it's simply the book value. Your total assets minus total liabilities does not capture the future potential unless it's a liquidation case in a commercial dispute. It's the combination of, therefore, income and market approach which is often used. I have statistics that shows that in the last 3 years in investor-state disputes, in 52% cases, tribunals have awarded a discounted cash flow method. 52% cases. Ezra, can we move to the statistics? Next slide, please. Next slide. Next. 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 Yeah, sorry, just go back. This one. That's it. This is the valuation approach of investor-state cases accepted by tribunal last 3 years. Sorry, all of you can't see that slide, but it's actually a pie chart that shows in 52% cases. And I know Noella is not going to like this, but this is not what I'm saying. This is what the statistics are saying. Times have changed. The tribunals have started accepting discounted cash flow method under income approach as a recommended method of calculating value of compensation, provided you build a robust, credible but-for scenario. You give contemporaneous evidences that you've relied upon. You give the history of operations. You ensure that financing is available. So subject to all those criteria that James and I talked about previously, the DCF has been one of the most popular methods. The second method being the cost approach, 26% cases. These are those cases which are early stage, where a discounted cash flow method is just not possible. It's too remote, it's too speculative. In those scenarios, generally, tribunals have relied upon the sunk cost with a pre-award interest, which is simply a commercial interest rate to compensate for the time value of money, as well as some opportunity cost of capital. Or, in one of the recent cases, actually tribunals have awarded a multiple of the sunk cost. It's like 2x or 2.5x of the sunk cost. Like the example you gave of $40 million, so it's 2x of $40 million. So these statistics clearly show that if counsel's approach is reasonable and the experts present a credible view on the compensation, tribunals are convinced on income approach and discounted cash flow method. Any questions? Happy to address.
I invite Noella to make comments on the DCF and particularly the compounding of interest in some of the cases that she's seen, because I know, just like you, that she's got clear views on this issue.
I think that I don't want to say much, but I think cases have been contrasted. You have the Bear Creek case, very similar to the PNID case in Nigeria, but very different outcomes. One outcome, 18 million USD damages, another 6.6 B USD damages, and no one can figure out why do we have this inconsistency. And we all, when we try and look into those decisions, we see that the DCF method is the one that made all the difference.
That's true.
And so obviously, as a lawyer representing a state, by the way, I've never represented the state. I've always represented investors. As a lawyer representing the state.
I will challenge the audience decision now.
I find it very difficult to accept a DCF method which then computes profits based on the life of the license or the life of the investment, which would be many years. So I'd want to resist that at every step of the way. I want to resist that.
So I want to give one example to you, Noella, and again, I disagree with her on this point. Risoro versus Venezuela Award, 2016, paragraph 756. Tribunals have clearly stated 7 factors that they considered in giving the value, awarding the value of compensation using the discounted cash flow method. Amazing award. When I say the word amazing, I want to highlight that the tribunals have clearly set out factors that help them in determining why discounted cash flow method should be applied and why they agreed with that method. Oftentimes, tribunals actually shy away from giving the exact reasons why they prefer one method or another. This is one award which I often cite because it's very helpful in determining what are the key factors that a tribunal is considered in awarding the damage or the compensation based on DCF. And that award actually spells out everything in detail in paragraph 756.
That award also awards 8.7 billion USD.
Yes.
I'll be very loud because actually.
I think though, trying to bridge the gap somewhat between my two panelists.
Please,
I think, obviously there is a lot of controversy around the use of DCF. It can be appropriate. If you have a project that has been up and running for a long time, that has been expropriated, it can be an appropriate thing to do. I think the important thing is, first, that we use it in the correct cases, and not, as I was saying, in a Nigerian PNID case where there is nothing. You go to the site, it's just a blank field. We can't be using DCF there, and tribunals need to understand that distinction. But secondly, when it is used, to use it appropriately. There are numerous, normally there's only a handful that are actually important, but there's always a whole world of assumptions that go into these models. And you mentioned one of the key ones in the UCOS case being the date of valuation. Often the risk factor is one that's debated over and over and over again. So I think it's about trying to get to some kind of reasonable understanding and educating tribunals on these things. Everybody switches up on quantum. It's always the last thing at the end of a long hearing. Numbers are not something that lawyers find easy. I say that myself as someone who's dealt with a lot of quantum arguments. But we need to do a better job of educating tribunals about these things. Absolutely. And what the appropriate time to use it and the appropriate assumptions to use and the impact that has. And just to also take Noella's side, I think that is an incumbent thing upon states to really up their game and get their own manals on board and explain these things to the tribunal. We see a lot of cases coming out where the tribunal has, particularly the criminal awards, where the tribunal saying, well, the respondent didn't provide any expert evidence on quantum or didn't substantiate these evidential points it was making. And that's the problem. And then the tribunal is left with very little option, but to go with the claimant's probably quite extreme approach. And maybe there is something to be said about putting more on the tribunal in those cases to try and assist the unrepresented state to kind of develop its ideas. But again, when you're talking about the complexities of a DCF model, it's just, you can't expect a tribunal to be able to do that. So it's a difficult balancing act, but I think we just need to make sure that we're using these tools correctly and appropriately.
Actually, James has brought up a very interesting point, and I was discussing during this week with Lawrence and with Aisha as well. I think there's a need for training of arbitrators. We often conduct these trainings under the SOAS University, and I've been doing that with Emilia Ondema and the SOAS University for almost 3 years now, where we conduct trainings for local law firms in Africa. But at the same time, it's important to organize trainings on damages for arbitrators. Because if they understand this concept clearly, I think there will be more fair justice in the arbitration.
Yeah, and having been in quite a few hearings are not the place to try and educate.
Absolutely.
There are too many conflicting voices and too many tired arbitrators.
And he's absolutely right. Our role comes right in the end. By the time arbitrators are already frustrated. Listening to both sides' counsel's argument, the opening submissions, and the fact witnesses, they're so frustrated. Their ability to grasp some of these technical concepts and valuation becomes constrained just because we are coming right at the end. So if we can do something like this, and again going back to Lawrence, we're happy to organize something like that.
Fantastic. Now, do I take it you were done with the slide that had the pie chart? Done with that?
I'm done with that. There are a couple of slides on types of damages that you wanted me to cover, only if there's time, otherwise we can
for now, I just want us to perhaps move on a little bit, but then
Sure.
I wonder, so there is a case which perhaps attendees can read at their own time, where I think a state did particularly well. This is the Philip Morris case versus Uruguay, where no award was made. The state was successful in that case, and the only aspect considered an adverse outcome for the state is that it had to pay $7 million in legal costs, and I think the point made by James earlier is important, which is better to say spend that kind of money on legal costs rather than having the billions and billions awarded against a state. So let's then segue into the question of the thing to watch out for in the processes that we discussed. What would be the things to watch out for as we go into these international and heavy commercial arbitrations, based on what your experience is, renowned for you as an expert witness, and then we'll come to counsel.
You mean you want me to cover some of the factors to watch out for?
Yes, precisely. What to watch out for when you're stepping into these arbitrations.
Sure. So I think I covered that through a slide earlier, but I'll quickly recap that. The factors.
Yes, maybe let's try 3 for now.
Okay, sure. So just very quickly, there are investment-related and valuation-related factors that one needs to watch out for. Investment-related factors would definitely include availability of contemporaneous evidence, what is the quality of evidence that's available, what is the history of the investor, to what extent it has carried out operations, whether they are profitable or not in the past. On the valuation side is the choice of valuation approach, use of alternate valuation approaches in transactions to triangulate your results under the primary approach. These are the key factors as an economic damages and valuation expert that I look out for, in addition to, of course, the legally pleaded positions that will be covered by the councils. Thank you.
Thank you. Kuram, any view on the critical aspects, irrespective? On this one, there's a neutral position I'd be asking for. So irrespective of who you are as a player, are there certain aspects that have stood out for you in your experience in this field?
Sure. So the starting point, I think, is quite a basic one, to just understand what the relevant contract or contracts say, understanding what the arbitration clause says, and that then allows counsel to roadmap what their cases, set up the case theory. So often I think it's crucial after counsel's had a chance to read the papers to set out a concise, very clear case theory, because a lot of the cases that develop from that, and of course that can be revised. But if we stick to the basics in terms of understanding what the governing law is going to be, getting a high-level understanding of what indication that has or something. So to take a quick example, as we know in some legal systems you can have the concept of good faith, which is enshrined in the contract. That comes up in common law systems, but it also, it comes up in some common law systems, like New York, for instance, but often it comes up in civil law systems. So if you have the same disputes on the facts, let's say in Germany or under German law versus, say, English law, there would be a very different approach that counsel would take. So I'm sure my colleagues are going to point out other factors, but I think for starters, it's important to just understand what do the relevant papers say and how the case theory is being developed.
Thank you for that. Nairobi?
Yeah, I think briefly, I would say the arbitral panel that you choose is an extremely big factor, and a lot of thought needs to go into the choice of the arbitrators. To reserve as much as possible the right to decide who that is, and not concede it to a third party unless necessary. So I think for me that's very key. The second thing is expertise, both in local law and international law. And it doesn't follow sometimes that the counsel we engage has expertise in both. They may have very good local law knowledge, but not very good international arbitration investment law knowledge, and you might need to consider having a team with both. Because I don't think you're likely to succeed if you have one or the other. I think you need to have both. And then the third thing that I think is very key is the quality of your evidence. My view has always been that cases are won on facts. And if your facts are weak, you fall back to the law. So the starting point must be the factual basis. And there is no excuse, there's simply no excuse in these high stakes kind of arbitrations for you not to know your facts and not to have gone and thoroughly accessed all the facts. If it meant going into offices and speaking to public officials, going to the ground to see what actually happened, because a case is won on the facts. The law, you plead the law when you have a weak case. So those are the three factors that I'd say, for me, are key when it comes to these kind of disputes.
Thank you very much, Noel. Actually, two critical points you've raised that I wanted us to delve into a little bit. The panel choice, and increasingly, we now having made his case for the expert and the money, and damage computation, maybe having somebody who actually understands that jargon is critical in these high-stakes games. And then the other, which I think was a bit of an eye-opener, is just go and see that empty site. It psychologically, I think, is an impact when you see nothing but debt. No excavators and nothing on site. So thank you for that. James, your aspects?
Firstly, I would just want to say that I completely agree with everything that Kamal and Noella have said. I think, in particular, Noella's point about having the right team. That mix of international investor understanding and the local aspects is really critical. It's something that comes up in pretty much every single, not quite, but the vast majority of cases that we do, and integrating the kind of local law team into the broader and true investor state expert team is really critical and a really important factor. And getting that right, getting that partnership is key. I think just one other possibly slightly controversial factor that I would like to just throw out for thought, and it's something that kind of Noella had touched upon earlier, is should we be saying to tribunals, you need to consider all of these factors. These are obviously very important to how you're going to value a claim, but you also need to consider the state and who the state is and what the state is capable of doing. And you need to consider the impact of your award upon the state's ability to look after its citizens across all of those assets, healthcare, education, all of that. Otherwise, you take the potential victim that is the investor, and we've all seen cases where investors put their quantum up too high. But in a lot of these cases, something has actually genuinely happened to the investor. We were talking about the Tanzania case earlier, where there was a genuine change in government process, something was expropriated. So the investor was a victim there. But are we at risk of also making the innocent citizens victims of this as well? And do we need to consider that? I think particularly where, this isn't obviously true of all cases, but in the majority of cases, you are talking about a state in the global south and an investor in the global north. And do we need to actually stop and think about the fairness of what we are doing with some of these awards? So I throw that out. I realise that is a somewhat controversial factor that is not in there, but I think it is worthy of consideration.
Thanks, James, and I think that's a good segue into inviting our audience to make comments and to ask questions. So at this juncture, thank you so much for listening to us, and I think we want to bring you into this conversation now. Any questions, comments, or observations that you'd like the panel to engage with you on? I know we've got a roving mic. There's somebody there at the back. Someone can help me get a mic.
Thank you for the panel and all protocol observed. Good afternoon. So my question is not related to particularly what we have talked about today. It's about the theme for the conference for this week, exploring perspectives for arbitration. So it's a twofold question. Has any of you, anyone in the room or the panelists, handled an arbitration or mediation case to do with a sports issue, anything to do with sports, an athlete, an organization, anything of the sort? And is there a market for it? Like, would it be a good idea for a young man such as I to invest 30 years of my life in such a sector? Because I would like to be assured that I'll have something to eat every morning. So that's my question.
All right, thank you, and we'll come to that. I think I might invite somebody from the audience to answer that particular question. We have somebody there, and at the back. We'll take another back as well.
Mine is directed to the expert witness. So I don't come from an accounting background, and we were talking about something to do with DCF, and the inference you made was that it's easier for companies that trade on the stock exchange. Oftentimes, some investors that are trading with the state are not companies trading on the stock exchange. So how would you deal with that sort of, how would you apply DCF in that sort of circumstance?
So just to understand your question, you want to know how to apply DCF for companies that are traded or not traded on?
Not traded.
Not traded on, okay. So to answer your question, discounted cash flow method and market multiples are two different approaches. When I say that you look at companies that are traded on stock exchange, those are the companies that are comparable to your company. Okay? Let's assume you are representing in a dispute a private company which is not traded on the stock exchange. So how will you use market approach there? You will first identify comparable companies that are publicly listed, calculate their multiples, and then apply them on your company. Okay? That's the market approach. Under the income approach, you apply the discounted cash flow method for your private company by looking at how that company is going to generate profits in the future. And the best way to start looking at that information is to actually rely on contemporaneous evidences, contemporaneous business plan. Let's assume you're representing an investor that started investing into a mining license or concession agreement 5 years back. 5 years back, when it actually made its first investment, it would have prepared certain financial projections. Those projections become contemporaneous documents indicating what is the expectation that the investor had from this particular license agreement going in future. Another very good contemporaneous evidence that helps you build discounted cash flow method is the business plan relied upon by the consortium of banks who provide financing to the investors. Often you'll see in infrastructure disputes where there is a huge capital investment requirement, the investor would go to a consortium of banks looking for financing, and the banks do a detailed due diligence themselves. So that business plan which the banks have relied upon becomes an excellent source of contemporaneous evidence. Why? It's not prepared by the either party, so it's not tainted. It's actually relied upon by a third party that is providing 70% of the financing needed for that project. So these are the, I would say, information that you need to ask your clients to help you develop or help your experts develop discounted cash flow method. Okay. Yes. Sorry, I'll just address the first question.
No, just a second.
Sorry.
Let me please take, I think there are 2 more questions on that side, and then we'll come back to you for follow-up. But let's take those other questions first, and I will come to you, Sergio. I will.
Thank you so much for the presentation. My name is Musumbu Onesimus. My question is related to the damage experts.
It's like I'm being cross-examined, right?
How do you calculate moral damages if at all it happens? We understand there are 2 modes of calculation of compensation, we have the fair market value, which may be they are found majorly on the case that has been determined by arbitral tribunal. And we have also the full reparation, which is supported by statute, I believe the INC draft articles of state responsibility. How can an investor plead in case there are moral damages, in case there is a moral damage? Do state just tell them, we are sorry, you have lost prestige, you have lost your reputation or business opportunity, stand up, continue with the business? How do you calculate in case of moral damages?
Okay, I'll give a very brief response.
Madam, just a second. Let me get more.
Sure. I hope it's not damages again.
No, it's not damages.
Thank you.
So my question is to Kuram, what is the tribunal, and by extension Noela and all the panelists. So taking you back to crippling awards, do you think it would make a difference if we had arbitrators in the panel, in the tribunal, who are from developing countries, who are obviously the claimants in these cases? Obviously, I would expect them to be more aligned to the distinctive requirements specific to these countries. So do you think it would make a difference if they were in these panels?
Before you hand back the mic, please tell us your name.
Oh, my name is Joy. Thank you, Joy.
On the mic? So you've got a hand up right there. I am coming to the side shortly.
Sorry, it's more of a Robert Wheelwright case. It's more of an observation, but I think it's sort of a segue from the sessions we had yesterday. One factor here is that many of these investors have third-party funders, and so these claims are being driven for cash in a lot of cases. That doesn't mean that there isn't actually an underlying merit to claim, but the people often running the cases, it's true of PNID, are now funders, vulture funds, if you want to call it, that sort of thing. The second thing to say is that has an upside and downside. It means that they are well funded, they are aggressive, but they need to make a commercial return. So if you take PNID, the damages are 11 billion. I find PNID an affront, and it's just a terrible award, and it's the adversarial system gone bad because Nigeria was not well represented in this case. There are other issues, but it was not well represented. But Nigeria's budget, it was in one of the Attorney General's bits of evidence to try and set aside the case, I think is 29 billion. So there is no way you're going to get 11 billion out of Nigeria. Nigeria has also been chased by creditors over the decades, so it's very good at not having assets hanging around. So at some stage, a deal will have to be done, and whether it's like the Pakistan deal, it won't be in that case because there isn't a prospect of working out. But a deal will have to be done, and that's the reality of these situations. You may see billions awarded, but they will not actually be recovered rather than a budget.
Super. Thank you for that. Before I then open it up, let's answer those questions, and then we'll take the rest of the questions from this way. Kuram, let me bring you to the conversation. There's a question from Joy. Would it be different if we had a diverse panel, a panel that would include and encompass developing arbitrators from developing countries and not with outcomes that we see?
So the short answer is yes. I mean, just to bear in mind, I think there is an increasing trend of more diversity along multiple lines. So if in this case we're talking about having better representation from people who have experience in developing countries to preside over cases that have some developing aspect. It is important. I think we're seeing more of it. Perhaps, depending on the type of case that we're talking about, or the sector, or the region, not enough. But I think one thing that's quite important is, from my standpoint at least, there is not a shortage of people who have the type of diversity that we're talking about. it's really crucial to make sure that on the competence side and on the experience side, they are really the sorts of people that you would want for your type of case. So once that's been decided, this goes a little bit to the point that I think Noella made in terms of how a tribunal is selected, particularly how the chair is selected. And then there's quite a bit, I think, of ringcraft that goes into that sometimes, especially in commercial arbitrations. And so once there's a sense of how that's going to happen, certainly in terms of a party being able to nominate someone on its side, there is some level of ability that that party has. And then, of course, I suppose the second order question there is, if you have, say, a tribunal of 3 people, and you've chosen someone whom you think has shown in their past experience a type of experience that would be relevant and has the kind of background that you might want, you have the other party that's chosen someone for its own strategic reasons. How is that chair going to be selected? And I think that is very crucial. I think this leads into the other points, so I won't go down those paths, but just to say that one of the challenges, I think, is, especially in high-profile or high-value cases, there's a bit of a, if I can call it a tenure bias, and sometimes there's obviously good reason for arbitrator chairs to be very, very experienced people, and sometimes there's perhaps less reason to have someone who's say in their late 70s or 80s, as sometimes happens. But the point is that the dynamic within that tribunal is quite important. So even if someone is able to choose a party-nominated person that is appropriate, if they are going to be bullied by a chair, then that's not good, and we sometimes see that happen.
Thank you for that. Noella, I'd like you to also comment on our diversity component, while at the same time providing an answer for our young gentleman who asked about the sports arbitration and I suppose all novel areas in which there's then growing interest in terms of developing skill.
Yeah, sure. Just to answer Joy, just to add on to what Kurema said, I agree with him. Yes, 100% yes. Diversity is important, and you don't need to look too far. You just need to look at the PID case, the Nigerian case. Chief Bayo Ajo was one of the arbitrators. He was Nigerian and he dissented. He's an ex-energy minister in the government, seasoned arbitrator, and understood that DCF would not be the applicable formula in those circumstances. And I think it was useful that there was a dissenting opinion in that arbitration. So I'd say yes, 100% yes. Have some diversity. In terms of the question asked by the young gentleman, whose name I forget now, sorry. Sadly, I do not do any sports arbitration, but I do know a very good arbitrator who does that. And I regret to say he is my competitor, John O'Hara, SC. Does sports arbitration. He is a former rugby player. He played for Kenya, and he would be the best person to mentor and speak to. And he's an extremely good arbitrator. So I'd say go for it. But when you have other matters, come to me.
That's a clever pitch, Noella. So then, James, I want to bring you to this question about the moral damages component, because I think that's really more or less an argument that would be advanced by the lawyers. I think Noella gave a heads up and talked about expanding the scope of arguments that one can present compellingly to the tribunals. Perhaps you can talk about the parameters that you ordinarily see being raised to justify a quantum for moral damages.
Yeah, sure. Just before that, I'd just like to say on the diversity point, if you're a state, appoint Noella. She's going to be a strong voice against DCF, so... but on the moral damages point, look, I mean, it can often be quite a difficult concept. I'm sure Noella will have some thoughts on actually the practicalities of quantifying these issues. They're very nebulous. I think you need to show compelling evidence, going back to what you were saying, about, you know, the things that if you were the state that you're claiming that the investor has done. Or you know, potentially vice versa. But I think tribunals are reticent to award much in those terms because it can be seen as so difficult to grapple with. You know, we've talked about DCF and its potential downsides, and Robert was talking about, you know, how PMID was, you know, a terrible judgment, and DCF should have been used for. But at least with that, you have, you know, you've got a model, and you've got an expert telling you how the model works and what assumptions have gone in. There's some kind of something for an arbitrator to latch onto and say, oh look, there's, you know, something happening here. I might not fully understand it, but, you know, I've been given it by an expert, and some calculations have been done based on numbers from reality. Moral damages are far more nebulous than that, and so I think arbitrators are not very keen on getting involved there, because there's just so much difficulty in you know, grabbing it back to reality and real numbers. But now I don't know what your thoughts are on actually trying to quantify these things, and how you try and go about it to make it meaningful to an arbitrator.
The simple answer to that question is we don't quantify it. Nobody can. I'm telling you, nobody can quantify reputational and moral damages. The underlying principle, the fundamental principle for assessment of damages, that has to be a real loss. There has to be an actual loss that the party has suffered. Now, there is a way you can quantify that, but not under the head of moral or reputational. So any reputational damage, any moral damage, if that has resulted in a cash loss to the party, if that has resulted in a negative impact on the profits of that claimant or the party, then to that extent you can still quantify those damages. But it would still not fall under the heading of moral or reputational, because there is no way. It's like goodwill. Can we quantify goodwill? Not really, except for the accounting concept of goodwill, which is a completely different issue. But for you to be able to claim reputational damages or moral damages, we need to ensure that there was indeed a negative impact on the profits or cash flows of the company. We need to look at, as James mentioned, evidences that will support that there was a negative impact on reputation which resulted in a loss to the company. You know, you had vendors, some of the vendors terminated contracts with you, or some of the other vendors said they're not going to work with you at lower profit margins, they'll charge you more now. So if you have these evidences, you can still try and claim some of the lost cash flows, but not directly as a reputation damage. I mean, you can see the history, pick up any award where reputational damage has been claimed. In none of those cases, the arbitrators have awarded that. So the key is causation, mitigation, and evidence to substantiate that this negative impact on reputation has in fact affected your profits. I don't know if you agree with that.
Thank you, Rinal. I then want to take the questions that I promised to come back to.
Good afternoon, everybody. My name is Masime. Over the week, we have had cases where awards are not given or set aside based on public policy issues. And I think Ms. Noella has spoken about the greater good for the citizenry as she presented her section today. I would like to ask, on matters where you have public policy awards being set aside, awards being set aside on public policy, does this then impact negatively on an investor? Because when we look at the Philip Morris case versus Uruguay, we had a lot of the United Nations commending Uruguay for its efforts to combat smoking and anti-tobacco campaigns and all of that. So does that now impact negatively on an investor? One. Two, would investors then shy away from investing in such a nation, knowing that an international body would then come in and kind of like stop or prevent them from getting an award in case there's a BIT award that is being claimed. Thank you.
Fantastic. Thank you so much, Masime. Please.
Good afternoon. Not a question to the panel, but an answer to the young gentleman who asked about sports arbitration. My name is Khairano, first of all, the founding director of Sports Legal, an international sports lawyer and arbitrator as well. Unfortunately, I haven't done any arbitrations yet, so I can't give you insight on that, but I think it's an untapped and underdeveloped area of law, generally sports law, sports arbitration, but it's highly potential, and I think one of the reasons, or rather we're discussing with Aisha today, and the madam here seated today, so she did, but yes, Catherine. And of course, with the recent workshop at earlier with the CSO Hamlet, she's mentioned, it's something that we're looking into developing, and we're also urging, local stakeholders, including Ncia, on how we can work together on capacity building forums and education and training in this sector. But I think yes, you can make money out of it, not yet. But I think yes, it's something that we can work on and hopefully grow into lucrative practice in the future. Thank you.
Thank you, Haruna. Please make sure you speak to our CEO, Lawrence Mondure. We will definitely want to take that up with you. Thank you. Any other questions or something? Yes. I'll come back.
Nianze kwa kukushukuru Kananu kwa namna ambavyo umeendesha mjadala huu siku hii ya leo. Majina yangu naitwa Usali Mwambene, natoka Dar es Salaam, Tanzania. Lakini pili, nipende pia kushukuru namna ambavyo dada Noela umetueleza umuhimu wa kutembelea eneo la mgogoro, hususan katika migogoro hii ya kimataifa. Na nafikiri naweza nikakiri kwamba kuna migogoro mingine tumepoteza au tumeshindwa kwa sababu tribunal haikupata nafasi ya kutembelea eneo la mgogoro. Na kwa kweli nakushukuru sana kwa hii fair comment ambao umetueleza leo. For the best interest ya other panelists, allow also me to comment for the wonderful discussion. Actually, this topic was very interesting, and it has been a very wonderful discussion this afternoon. Now, just a quick question. And my question, I think, it will be rather a hypothetical question, because personally, I have a feeling that sometimes these tribunals make decisions and render awards which somehow have elements of deterring. That is my feeling. Now, since we have a representative from tribunals or any other panelists, would have to take that as well. But I would love also to extend the conversation probably with Noela or any other panelists. I think the plead, apart from the plead of human rights and the plead of public policy, or rather there could be some other common pleads that we can use to have these ridiculous awards being set aside. So if there is, please share with us. Thank you so much.
Thank you. Before I turn to the panelists, anybody else who would like to direct something? And thank you so much, Usate. We are learning that Kiswahili. Kenya tutafuata hiyo mwenendo. Anyone else with a question? Okay, I will turn to the panelists, and if you still have a question, please let me know, because again, I'm mindful that we have overrun somewhat. So let me turn back to you for a start. A couple of things have been raised. Masime has raised a question about the impact of these awards, and I think it's a very good aspect of these discussions, the impact that they have on the country. I think you mentioned that a little bit in terms of diverting public funds, and then also the impact on future investor attractiveness. A critical component here is the question also of public participation, whether it's internally within that country or interests coming up to push an agenda that might be either pertaining environment or health or any other such consideration that would be important. I think now we're seeing a big play on environment and ESG, so maybe you can comment on how that plays into these awards.
Yeah, thank you. Masina, I think you raised a good point. So one of the problems that possibly Kenya has had with this public policy argument is it's very wide, and then we rely on Justice Wingera's definition of the unruly horse, and the fact that it is transient. It changes in time, so at any given point in time, an investor has no clue what the public policy is. So that's the downside, and I don't know if the solution is to have a bit more of a narrow definition of what public policy means in the context of, say, Kenya. I don't know if that is the solution and whether it is desirable, or it was always intended for it to be amorphous or ambiguous enough so that then the state can rely on it, or whoever can rely on it as and when they wish to, because it is ever changing. But I think one of the good things about the public policy arguments, I think it allows us to set aside the words that don't take into consideration what is a very important growing discussion on environmental issues and the impact on climate change and ESG. And I think that to use public policy as a tool to defend those issues is noble. And so on the one hand, I would be reluctant to really narrow down the use of public policy. So you kind of have to choose your battle. Do you want to attract investors, or else they must come? So then you open it up completely, even kind of narrow down. Or do you want to have a balance? So you want to attract investors, but on the other hand, you want to protect the interests of the state and its right to environmental issues and human rights citizens. So that's my short answer to that. And then thank you for your comments, Asante. Yes, there are strategies I think that we can use, and I can share them at a few, of course. I'm joking.
Second on that, Noella, I haven't come to that question, but I do want to come to it because I think it was a very pointed one on the benefits.
Okay, so I can stop right there.
You can stop there, but then I think, to our neighbors, we must surely be able to speak the committee and no fees for now. But he did raise, maybe for the benefit of the tribunal, I can say a little bit about what was mentioned before. He was very grateful for some of the insights that Noella gave, particularly that one touching on the importance of site visits. And in fact, one of the points that he made is that there might be some cases where they've been lost because there haven't been any site visits by the tribunal to see what's on the ground. So I would like perhaps to invite you, James, to make a comment on whether this is something that you witness. I think we'll be speaking more or less from the African perspective. Are there some cases you've seen, not just in Africa, but outside of Africa, that have had this issue at play about literally not having any viable investment?
Yeah, I mean, it's definitely something that comes out a lot in the cases is that no investment has been made, and the differing approach to that. And I personally love a site visit. I try and encourage them on a number of my cases, on both sides. Sometimes actually, when acting for the investor, you want to go and show how great what has been built is, because there actually is something there on the ground. But I agree that the counter argument works the same, that where there is nothing, go and show them that. But again, I go back to the point we were making earlier, right? You also then need to educate the tribunal as to the impact of there being nothing on how they come and value losses at the end. So it's both are important. You need to obviously show them there's nothing there, but then you need to also say to them, and therefore the impact of that is you shouldn't be doing DCF. So yeah, I'm a big believer in site visits, and I don't know how many have taken place in Africa. I haven't personally done one in Africa yet, but I've done them in other parts of the world, again, in relatively remote locations. So as long as your tribunal are willing to go and do it, and I've seen some tribunals who are positively ecstatic about the chance to do it. Even, you know, going back to the diversity point, and sometimes the lack of diversity, even some quite old white guys quite like it to go out and try and get out on site. So don't let that put you off. And yeah, I think it's a good thing, one thing we should be doing more of.
Super. And yes, one of the comments that I'd like to make, maybe is to just bear this in mind with this crippling awareness. The deterrence effect, and I'm glad that was brought out, is one that we're quite mindful of, I think, even as a panel, because there's been the deterrence where the governments then wonder how to direct their funds, whether this should go to public health, environment, or other interests that that nation might have. Then there's the hindering of regulatory efforts within a government and limiting of that government's liability. But these are things that I think when we spoke yesterday, the question of each nation or each country thinking about its own interests as it comes into this conversation. So the negotiation of those agreements and the participation, I think on day 2, we spoke about the question of the contingent that goes into negotiating a lot of these agreements. Are we having, this maybe for the benefit of the panelists I'll mention, there was the question about whether the key principles for some states actually engage in those closed-door meetings or go off shopping and leaving substantially junior people to negotiate these very, very critical agreements. The economic impact of these agreements is also, or the consequences of these awards is something that we also bear in mind for governments and businesses because they have severe economic consequences. The investor confidence is also something else that we ought to think about because there's an impact on FDI depending on whether there's any trust in the process, not necessarily the outcomes because the outcomes may vary, but the processes. And I think this is why the case of White Industries, the Australian company versus India was important because that criticized the processes provided by the Indian state in resolving the dispute. So all these are quite critical. Sovereignty, obviously, is a major one. So I want to then come back to that important question that's been raised. When these attacks are made against states, what are some of the defenses that can be used robustly in your experience and some of what you've seen in these cases? What are some of those strategic defenses that you would say these, depending on the nature of your cases, could be the ones that you highlight and hinge the success of your outcomes of? Kuram, I don't know if we start with you. Do you want to comment on that maybe?
Just to clarify, do we mean in terms of what the, based on what the facts look like? Because obviously that's going to drive.
Just in terms of an example, perhaps, if investor claims are presented against the state, and I do believe that's a perspective that person came from, what some of the defenses you've seen them successful are?
So, again, I think the factual matrix is huge, and this is something that I think Noel said in a different context earlier. I think that is a starting point. So that's one starting point to really just understand what is the context of the dispute, because although we tend to lump investor-state disputes in one category, there's quite a range in terms of the types of underlying projects or investments that there are. So that needs to be borne in mind. Then the other factor that we mentioned a little while earlier is a very clear-eyed view of what is the dispute mechanism that's available, and the details of that matter. And so I won't go into that much more, but that analysis is also crucial and consequential. I think that there is often a concern from the outset on the public policy aspect, and that is important. But it's, from my standpoint, important to apply a disciplined approach to that, because there might be some arguments that would be available depending on what the legislation says. To your point earlier, often, if we're talking about public policy, it's a bit vague, sometimes intentionally. But whatever the case is, it's really important to not put forward arguments that are, at the end of the day, not credible. And I think that because there tends to be a little bit of cynicism around public policy arguments and certain other defenses which are not your, say, vanilla defenses to a matter, I think it's crucial to chart those out, take a step back, take stock, and say, is this persuasive? And do I need to tone this down a bit? And then the one final technical point I'll just mention is that, in my experience, what's often helpful is to break some of the arguments into tiered arguments, into fallback arguments, and allow the tribunal to sit somewhere between option 1 and perhaps option 3, and not give them the feeling that you're forcing them into a particular position and it's all or nothing, because that could be binary and you could lose badly on that.
Thank you. Ala, please share some insights without cost.
Oh, I was going to say I don't send my keynote. No, I'm just joking. But I want to start where you stopped. You know, one of the most compelling arguments against full reparation is it gives you an all or nothing outcome. And that's one of the things that you can start with by telling the tribunal that if we go for a full reparation, satisfaction, restitution, compensation, it's an all or nothing. And arbitral tribunals kind of like to be in the middle. They don't like to be in any extreme end. And so that's one compelling point that you can make. Obviously, all the other arguments that you can make are innovative. They've not been cast in stone, they've not been accepted, you know, unconditionally under international law. But if I was to list them, is first of all start by making the argument. It's very interesting that states don't make the argument that they will be impecunious if you award these damages. No state says that. So I think the starting point is actually make that factual argument. And then the second thing is you can think of the principle of proportionality as a legal concept. And I think in Kenya, it is actually recognized as a concept of whether, you know, whatever relief you're seeking, you know, outweighs the harm that it will cause, etc., etc. So that's one. I know there's scholars who have talked about applying the principle of necessity. That's another one. I'm not too clear on how that would work, but it's worth looking into. Again, if it's a Kenyan case or it has Kenya law implications, you can take a human rights angle, so that if it will impact on any of the socioeconomic rights, you can then say that this award would be against public policy, because it results in the breach of another important human right. The other thing that you could look into is robustly challenging the valuation methods that have been adopted. And that may or may not result in, you know, a less and then you can borrow from, it hasn't been recognized as customary international law, but you can borrow from the reparation awards that were issued during the World War II, and the sort of jurisprudence that came out of the awards that were being issued. And there was a recognition both against Japan, against Germany, that looked to make these awards would really destabilize. And these countries, you know, in the aftermath of the war, do not have the adequate resources to settle this. So we don't want to make a paper judgment. Let's think of something more viable. So you can look into those stories and the jurisprudence that emerged there. I don't think it has been elevated to the point of customary international law. I don't think it has been accepted, but it's worth making the argument. And then finally, of course, it's just you know, the contracts that you sign in advance. So I'd say those are some thoughts. Whether they will work or not, I'm not sure. So don't hold me to this, given that fees has not been paid. But we can start having a conversation around that and thinking about that.
Thank you, Noela. James?
Yeah, I mean, I would definitely echo all of those points as well. I think, yeah, you need to look at it from the whole way down from how you're entering your contract to then how you're pursuing your dispute, and as you said, making sure that you properly challenge perhaps the more extreme valuation criteria that are being used. Once you get to enforcement, I think there are no, as yet, accepted methods for, there are kind of no vanilla defences on crippling damages, because it's a relatively newish concept. And as you said, states haven't been willing to go there. I think one of the things we need is we need a state to be brave enough and take that first step. Because what it's going to mean is opening up your budget, opening up your books, and especially if you're an ICSID, that means it's public. And you're publicly stating, we don't have much money. So you have to have a state that's willing to go there and try that argument. And I can see why states haven't, because there's definitely there's a political risk to the government saying, oh, well, we messed up here. But there's also that kind of external risk to investors of, we're broke. Well, we're not really encouraging investment there. So I think we need a state that's willing to go there and do that and make the argument. And then I think you can bring in things like Noella said, there's human rights. Just go back to first principles, as you said, on the Germany-Japan thing, but also just when this system of full reparations was agreed, nobody thought of TCF. Nobody thought that we were going to have billion-dollar awards against states where, as you said, with PNID, sorry, it might have been Robert said, with PNID, where the award is like half the annual budget of the state. That was just never envisaged, and we need to actually go back to first principles and start thinking about this again. But like I said, we need a state to be brave enough. And just one last thing on the deterrence point. I think we really need to think about deterrence in law generally, but particularly in commercial law. I do not see that commercial law, investor law, is a place where deterrence should be something that is being considered. If an investor has been wronged, compensate them, but compensate them for the amount that they have lost. Don't give them more because you're trying to stop the state from doing it again. That is not a principle that I think we can bring into international commercial disputes. It's just wrong. States have a right to do what they want to do. If it harms somebody, then that person should be compensated. But to try and say, well, we want to impose a system upon you where you're not going to act like this because we don't like that, and we're going to impose greater financial sanctions on you in order to make you comply, that's just simply wrong.
I think you want to react to that?
Yeah, just a quick one. So I agree with everything that the panelists have said. I think sometimes we also have to bear in mind that there are often more technical or sometimes tactical procedure-based defenses that are available. So we, in these types of discussions, we're obviously keen to explore some of these the kind of deep philosophical issues and sort of civics issues here. But in the case of many of the exhibit or sort of the awards that don't become fully fledged exit cases, they can fail on points such as something not being an investment or an investor, right? So the, if I can call it the kind of technical defenses at those early stages are also crucial and worth putting the effort in to make sure that if you're acting for the state, you don't want the other side to get over that hump.
No, thank you very much, and I think that just entwined to the point that Noella had made about knowing the domestic law, knowing the international law, and then taking advantage of that knowledge that you have about the nature of the case. Now, with that said, I think I am told I am out of time. I want you to kindly join me in thanking this panel exceedingly. Insightful and truly appreciated in terms of wrapping up a lot of the information that we received in the course of the week about different things that states can do. And I hope for any state lawyers that we may have, or anybody from the government side, one of the things to take away is actually being at the table when a lot of these negotiations are being discussed, and also for lawyers to be in the rooms and express their views on what they think ought to be borne in mind by contracting parties at the outset. So thank you so much to my panelists. Lawrence, do I hand over back to you so that then we can have our break. So thank you better than verbally. Make up your fees.
So another round of applause for the team. Fairly novel, yet very complex subject, and I think they've done justice to it. You almost feel like you should have another afternoon, yeah? But I know there's so many other events we are waiting for. I can already see people are prepared for them. So we will also excuse them. We had tons of work just to prepare for this. A lot has gone behind that. And I think that's what they are alluding to. Case preparation in itself is important. 80% preparation, 20% execution. And they've done justice. Let's clap for them. So before we break for lunch, we have another exciting conversation in the afternoon, but before we get there, we want also to give something to the panelists, so I invite the chair to kindly come forward, take a photo. So maybe you can stand and take a good photo, and then we'll do the gift.
Before I give this gift to James specifically, I want to say something. For those of you who've been here since Monday, you know how many times James has been on this side of the podium, right? So I am campaigning. James wants to go to the game park tomorrow morning. That is a work in progress, but I don't want him to go alone. So anybody who is available and ready to accompany James to the game park, 6 a.m. I don't know what time he's going. He'll tell us what. Oh, okay, all right, that too. So anybody who's ready and willing to accompany James, please, let's not let him go to the game park on his own. We want him back here next year. We don't want him wandering on his own to look for the big five. So anybody who's available, please do join James. James, really, really thank you. Thank you.